Jasmine Brasinho.
She's not here. You've already issued a warrant on a violation report on this case. I want to say 2 weeks ago. She has reoffended. She's in the wind. I have communication with her, trying to get her to turn herself in. She didn't want to do it. The only concern I have is we're on today's bond. I know she's not here. She already has a warrant on the case, so I'm asking the court if the court could do an increase or a judge's warrant.
No, I've already done a judge's warrant on
Okay.
the
So,
violation. Yes,
Okay, that's what I thought.
yes.
But I just wanted to make sure everything was.
No. There's a judge's warrant that was issued on the trial violation report.
Did the bond double? Or?
No, there shouldn't
Oh, it's-
be any bond. Yes.
Okay.
Because normally when I do, well, the rules are when I do a judge's warrant, the bond, if somebody wants a bond, it comes back to me.
Okay, that's fine. Once she gets picked up, she will have to remain in. They will not be able to afford the situation. So that's the update.
All right, thank you.
And have a good Christmas.
Oh, you
and
too.
New Year.
Devontae Williams.
They should be here.
We're ready.
All right, come forward.
Can
Can I run to another court?
Check in.
Okay.
Morning, Judge.
Good morning.
Juan Pablo Leon.
Right behind that black line.
He's in custody.
All right, today is the plea deadline date.
So Judge, I'm asking the court if the court would kindly give us a reset to that first week of January as a plea bargain deadline. Mr. Williams has a new phone number that I got this morning. I just want to be able to run through everything with him before making a determination. I think it's possible we work this case out. I've got to go do orientation for drug court this morning.
Okay,
So I'm gonna work as much as I can with him
Mhm.
here. But I need to be able to cut out to go get that done, if that's okay with the court.
yes. All right, Ms. Ferguson, I need a plea deadline date for the first week in January, please.
We can do, January 7th.
All right, January 7th will be your final plea deadline date. The court will not accept any plea bargain agreements after that date. If you decide to enter a plea, the court will only accept it with good cause. Otherwise, you'll have to plead oath to the court. You understand? All right, just have a seat. Once you sign the reset form, you're excused. And do you have all discovery?
Yes, I do, Judge.
All right, thank you.
Thank you, Your Honor.
All right, Walter Prince. Hello, Mr. Prince. Hi. Hi, why do you keep missing your TAP evaluation and your PSI?
Set the date wrong the first time I did, when I went in, they see me, but, they had rescheduled. Then, I just went Tuesday, and, we finished the, what's called, scheduling a date for January the 6th. Well, psych evaluation.
No, that's not supposed to be scheduled. I asked you all whether or not there were some mental health issues and your defense counsel told me no. So are there mental health issues with you? Have you ever been diagnosed with a mental health issue? Have you ever been on, you need to speak up, I can't hear you. Have you ever been on any type of medications?
No, ma'am. The only medications he's been on, Your Honor, that I'm aware of is his cancer treatment.
Okay,
He has not informed me of being diagnosed with anything like bipolar or any of those other things with respect to any type of psychotropic drugs or treatments. So I do not have any knowledge. I only am basing what Mr. Prince has told me about his history regarding mental health.
what cancer treatments?
I have leukemia.
Okay,
Not some medication for
okay, and do you have proof of that or are you just taking his word?
If I may, Your Honor, I have about 55 pages of medical records. They're not exactly complete. They came from his mother. I can turn those to the court right now. Let me get to my file, John.
All right, Mr. Prince, if you'll have a seat. Danielle Garcia. So state, did you tender an offer?
I did, yes, Your Honor.
All right. All right, Ms. Ferguson,
Yes, ma'am.
set this for a plea deadline date, that first week in January. And I'll need an acknowledgement of discovery completed.
The 7th.
All right, thank you.
All right, appreciate it.
January 7th is going to be your plea deadline date. At that time, you need to let the court know whether you're entering a plea or not. If you don't, then you're set for jury trial.
Okay.
All right, just have a seat. And once you sign the reset form, you excuse.
Okay, thank you, Your Honor.
You're welcome. All right, Walter Prince. Court is calling 2025 CR 006467. State versus Walter Prince. Could I have parties announced for the record for the state, for the defense?
Joseph Appelt.
And you're Mr. Prince? All right, Mr. Prince, you entered a plea bargain agreement with the state to count one. The enhancement was found to be true. My understanding is that the plea bargain agreement, the state is to remain silent on your application, and punishment is to be assessed at a cap of 7 years. And there's to be no contact with UT Health Science Center except for medical treatment. All right, Mr. Prince. It appears you have a problem with stealing. So why, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Walter Prince.
All right, why do you steal? Why are you stealing? Well, I mean, you do know, because it takes some thought to do it. And let me just tell you, the only reason why the state is silent, the only reason why you're going to receive probation for this from this court is because of your medical issues. And I know that the jail and the prison system, they're not 100% equipped to provide you treatment you need for your leukemia. Otherwise, you should be going to prison. And obviously, maybe there's something mentally going on with you. Usually I know when people are going through treatment, sometimes they need therapists for mental health, because sometimes treatment is a roller coaster. You're doing great, you're not doing great. So I understand that. And your attorney has brought to the state's attention and to the court's attention the fact that it is true that that's your diagnosis, that you have been receiving treatment. And that is why you've been at the Health Science Center. So this is what I'm going to tell you. I'm going to grant your application. However, I will only grant your application if you're applying for deferred adjudication. And I do have your application for deferred adjudication. And I'm going to place you on deferred adjudication. And you know why I'm doing that? Because if for some reason you were revoked, you're subject to the full range of punishment, and that's up to 20 years in the prison. So you had better not steal anymore. You understand? If you want things, you need to work for things, and you can not use the fact that you have medical issues as an excuse to steal. All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. The mouse is slow.
One factor and component I think the court needs to be aware of as well, in his medical records, it does indicate that he has been diagnosed with partial idiopathic epilepsy with seizures.
Okay.
So that'd be a physical thing, not a mental issue. However, I'm not sure how that would be addressed other than through medical procedures and medical medication.
Okay. All right, there's going to be 6 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. Are you employed? So how do you support yourself?
I'm getting assistance from my family.
Okay, I cannot hear you. You're going to have to speak up.
Sorry.
That's okay.
I'm getting assistance from my family.
Okay. And do you live with someone or you live by yourself?
By myself.
All right. Do you have any children?
They're grown.
All right, there's going to be proof of employment within 45 days or proof of SSI within 45 days. Or you can provide medical documentation that he's unable to work, and that needs to be done within 45 days. If not, he'll obtain employment, and he's not allowed to have any employment as a home healthcare provider or with minors. There's a $1,500 fine that will be probated. There's to be no contact with the Health Science Center except for treatment. Restitution, if any, to Melinda Stelp, STELPFLUG. There's going to be 100 hours of community service restitution. I'm going to require the anti-theft course. And Ms. Abrams, when is his MIC evaluation scheduled? All right, and he's to attend the MIC evaluation. If you miss that evaluation, a motion to revoke is going to be filed. You understand? All right, field visits, 1 time per month for 8 months. Probation, is there anything else?
No, sir.
Do y'all need him to do a medical release?
Judge. Your officer will go over that with Judge.
All right, so you'll need to provide any type of medical information. If your doctor says you aren't able to work, you'll need to provide that to probation, and you need to do that within 45 days. Do you understand?
Yes.
All right, is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, you had better follow through on everything, otherwise it's not going to go well. You understand? All right, just have a seat. Probation will go over conditions with you.
Thank you, Your Honor. May I be excused?
Yes, thank you. Alberto Acosta. Gary, you are one of the lucky ones.
I
Your
am.
client is here.
Oh, yeah.
He made it. All right. Where are we on this case? Has the competency evaluation?
Oh, no, it was just filed after the first setting
Okay.
on the case, and I think it's,
They have it set for March 12th.
well, yeah, something like that.
All right. Norma, give me a date after March 12th.
March 30th.
That sounds good.
Okay, so what's happening is we're bringing you back on March 30th. Your competency evaluation is not till March 12th. I have no control over that. Once a request for competency has been made, I must grant that request. Okay? All right, thank you.
Yeah, good luck.
All right, Francisco Alvarado and Bob Behrens, where are you? Francisco Alvarado, Bob Behrens, last call.
For present, Judge, I was being held in the meeting room.
All right, today is the plea deadline date.
Yes, would you like to talk to the prosecutor about getting the paperwork?
All right, so to the prosecutors, it's on page 13, Francisco Alvarado. They want to accept the plea. And if you could prepare the paperwork. All right, Mr. Behrens, if you can contact the coordinator, she'll need your email address and your client's email address.
Yes, will do.
If he's clean to both cases.
And also what you're pleading to.
All right. But I would need to talk to the state, see which one we're pleading on.
All right. I'll place you in breakout room number 1, you and your client.
Thank you. Well, can I speak to the DA? That's who I need to talk to.
Yes, if you go to breakout room number 1, they will call you.
All right.
Thank you. Laura Cruz? Johnny, where's your mentor, your mentee?
She's over there.
She should come up.
Yes.
You have really done great with your mentor. He's always great.
Thank you, Your Honor.
So
She's-
on,
She's the third one I've had, and I've got one coming in January, another one, and she'll be with me in January also.
so awesome.
So,
You will learn so much from top to bottom about this system on the criminal side and on the civil side. He's like really a great mentor to have.
Yeah, it's definitely a information overload, but it's interesting. So.
Oh, yeah.
she learned everything in one day because that's all I know.
But I've sent some of my students to him and they always enjoy it. And they keep coming back to him. He now becomes a second parent too.
That's true.
All right, so today is the plea deadline date. So,
Your Honor, there's the district attorney's office is going to interview the complaining witness. I feel like they have some issues with the case,
Mhm.
and they're going to interview her, I believe, this month in December. And I want to know if something new is going to come out of that interview that maybe will help us in one way or another. You know, compare notes and statements, et cetera. So I'd like to have another extension on that so that I can see what's going to happen with that. I don't want to not be fully prepared.
all right, Ms. Ferguson,
Yes, ma'am.
on this case, I'm gonna need a jury trial date and a plea deadline date. So you'll be either in jury trial or you all will have reached an agreement. How long do y'all expect this trial to last?
Your Honor, from the state, maybe 2 days for a case of chief.
That's what I think also, 2 days.
All right, Ms. Ferguson, 2 days. Do not, you read my mind. I was gonna say, don't go past March. So your jury trial date and plea deadline date is gonna be March 10th.
That's my anniversary, 53rd years,
Oh,
53 years.
well,
Congratulations.
And I'd rather be here than there.
Norman, you can't break up his marriage.
No, I've had a happy marriage.
Yeah.
Thank you, Your Honor.
So we were gonna give you another date.
Yes, ma'am, March the 10th, and
Oh, you're fine with March the 10th?
that's fine.
Oh, okay.
Fine.
All right. His wife will know that
Yeah.
we offered. All right, we'll see y'all March
If
the
it
10th.
doesn't go into the evening, I'll be okay.
Okay. Once y'all sign the reset form, you'll be excused.
Thank you.
Thank you, Judge.
All right, Samuel, Lamone. All right, today is plea PTD date. Has everything been signed?
Everything's been signed. He's been accepted. I had him do it again this morning, called orientation and left a message.
Okay. All right, Ms. Ferguson, I need a PTD date.
Yes, ma'am. 22nd, January 22nd.
All right, January 22nd. Once you sign the reset form, you're excused. Make sure you follow through on everything, all right? All right, just have a seat. Your attorney will bring the reset form to you. Thank you. Thank you. Gabriel Carvajal. I know. I don't know what to see. The H and the L's always throw me off. What's your last name for me, please? Carvalho.
Yes, ma'am.
Oh, okay. So the H is silent.
And that thing is you look them up on the clerk on Odyssey, they've got them under 2 different spellings, so you can't, and it's not, none of them are right.
Oh. All right, so on this case.
We were to have a,
Discovery.
yes, discovery, and we were to have an offer by today. We received an offer, which my client got it today, and he's going to consider it. And we believe we've received all the discovery. I had an inquiry on a couple of things. State got back to me, I think yesterday or the day before, that the evidence does not exist. And so, or they can't find it, whatever. So we're asking for time for my client to be able to consider the offer.
How old are you?
21.
All right, Ms. Ferguson, set this for a plea deadline date, the second week in January.
Yes, ma'am. I can do that.
All right, there you,
Is it a
that would be
Friday?
your plea deadline date. No, it's not a Friday.
Tuesday.
Okay, that's fine.
All right, once you sign the reset form, you'll be excused. If an agreement is not reached on that day, it's going to be a quick turnaround for a jury trial. Do you understand?
Yes, ma'am.
All right, thank you. And I'll need an acknowledgement of discovery.
Got it.
Oh, Well, pass here.
We're
Thank
on
you.
it, Jay.
You are anticipating today. I love it. All right, just have a seat. And once you sign the reset form, you're excused.
Thank you.
You're welcome. Akira Santiago.
Step out and call him.
Yeah, I don't. Oh. Akira Santiago, you'll need to show your video.
I'm sorry about that. I couldn't figure it out. There it is.
Step out and call him.
Yeah, today's the plea deadline date.
Yes, sir.
Santiago, you'll need to show your video. I don't know what she's doing, but okay.
We're still working on getting the discovery, Judge. We've got most of it, I think. Haven't had a chance to go through it. They're gonna provide us some more. We'd like to reset this for another pretrial.
Judge, so Melissa Christian was appointed on this case. He's just been retained on it. So I'm in the process of getting him the discovery. Another thing is that when this case was turned in to us, there was reference of an ancillary investigation that they did not turn discovery over on. But in talking with counsel, I did reach out to the police department prior to today and ask for that discovery. It wasn't sent over, and then I just called the detective right now. He did send me the reports associated with it, but he is still working on getting the videos. But it would either be 404 or play into a defense that he's trying to go about investigating. So I think if we could have one more discovery, but there is an offer, but I guess depending on what we receive from the police department, it may change it.
All right. Your plea deadline date, your final plea deadline date is going to be the second week in January. It would not be further extended. If an agreement is not reached, your next court date is going to be a jury trial date, and she'll need to appear in person for that jury trial date. Ms. Ferguson, I need a date, second week in January, please.
January.
All right, January 13th.
Yes, Your Honor, at 9 a.m.
Yes,
Thank you, Judge. Are we excused?
yes, thank you.
And that was the deadline, Judge?
Yes,
Thank you.
January 13th, right?
yes,
Thank you, Judge.
you're welcome.
There's no bond.
Who's here on Jonathan Tavares Carter? Court is calling 2025 CR 007350 State versus Jonathan Carter. Can I have parties announced for the record for the state?
Jeffrey Wright for the state.
Defense?
House.
And are you Mr. Carter?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. On this system, it has his attorney as Caitlin knows.
She's in the same firm I am, and I'm covering for her.
All right, any objections?
Mhm.
All right, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, we can go off the record. All right, with your plea bargain agreement, this 2 years, that needs to be below the line. Because there needs to be no confusion that his receiving 2 years deferred adjudication, you all cannot agree to that. And these other conditions, that needs to be below the line.
Okay.
So if y'all want to just write that in below the line and well, state, are you all able to just print out a sheet that's the plea bargain page, just that one sheet?
Yes.
All right, they'll print it out. So y'all need to redo this part and then you can attach it and then the clerk can go over that with you again. But the only thing that y'all can agree on is the recommendation of whether it's deferred or not, but the length of time can't be up here. And all of these conditions that you're recommending needs to be below the line because the court sets the conditions.
Okay.
All right. So I'm going to give you all this. So if y'all will fill out that sheet and then just approach me when you're ready. Oh, did y'all complete the certification of defendant's rights?
I'm doing it right now, Judge.
All right, thank you.
Yes.
All right, the court is calling 2015 CR 3473 State versus Rose Padilla. Could I have parties announced for the record for the state? For the defense?
Robert Valdez for the defense.
And are you Miss Padilla? You need to, okay, everybody is whispering. Why is everybody whispering? You need to speak up so the court can hear.
Yes.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rose Padilla who's placed on deferred adjudication for the offense of aggravated assault with a deadly weapon on September 9, 2015 for a period of 5 years and extended for a total of 5 years? Is that you?
Yes, ma'am.
All right, state.
Judge, if I can have just some.
All right. All right, we're back on the record. You may proceed.
By violation of condition number 10 in Bear County, Texas, between the date the defendant Rose Padilla was placed on community supervision and the date of filing hereof for restitution, the defendant should have remitted $81,135.98, but has only remitted $2,504 in violation of condition number 10.
How do you plead to that? True or not true?
Not true.
Violation of condition number 21, on or about the 17th day of June 2025 in Bear County, Texas, the defendant Rose Padilla did then and there call to complete GED as instructed by the court in violation of condition number 21.
How do you plead to that?
Not true.
And violation of condition number 23 in Bear County, Texas, the defendant Rose Padilla did then and there fail to make payments of $100 every 2 weeks in violation of condition number 23.
How do you plead to that? True or not true?
Not true.
All right. Will you all be ready to proceed on a contested hearing the second or third week in January?
Judge, you said the second week of January.
Second or third week?
Yes.
All right. Oh, we can bring it. No, I'll do it. It's fine. All right, what date?
It would be the 12th.
But it is a simple case. Okay, we'll just do it on the 12th. Unless somebody wants to do it now and have the probation officer zoom in.
Judge, the officer.
All right, we can do the contested hearing now. They'll have an officer zoom in. Everybody just have a seat. We'll see if the officer can zoom in. Jeffrey Dollar.
He's an inmate. He,
Okay, it shows him on bond on the docket. Did they even order him?
So my understanding is that he's been in Bear County Jail. From his family, he was transferred to Medina County Jail like 2 days ago. They informed me that he was transferred back in last night.
Can you all check to see if he's,
That's exactly what I'm saying.
well, why is it listed on the system as on bond?
I have no idea. That has to do with booking, Judge.
And he, since then, he's been remanded without bond on this case for a period of time.
All right, so was he ordered or no?
No, Judge, he's not.
See if he can appear by Zoom.
He's still in the booking process, Judge. I don't know if he's done.
Is it booking not completed?
All right. So what is happening with this case?
I've met with him. I've gone over discovery with him on the video. I'm in the process of filing pretrial motions. He had asked me to present a motion to set bond today to the court. I presume we'll wait till he makes an appearance. At the moment, we do seem to have a good working relationship. That's where we're at right now. This is my first setting. I don't have an offer yet. I think it's an older case. I think Robert Mauer was on the case, but I don't have an offer yet. So that's where we're at.
Okay.
Judge, he was supposed to hire an attorney. He wanted to hire his own attorney. I don't know.
No, I already, yes, he wants to stay with him. All right, Norma, recall this for the first week in January.
January 7th.
All right, you'll be back on January 7th.
Thank you, Judge.
You're welcome.
Setting judge.
You can put it as you all have to confer off docket. You can put it as a plea deadline date. And Norma, put a hold on him so he doesn't get sent anywhere else. All right, who else is ready?
Page 18, last one at the bottom, Rolando Gomez.
Rolando Gomez.
Judge, we're present here.
So, Your Honor, we're set for a contested hearing today. I know the discovery showed up in Veripick on the 15th. I'm not sure if.
Can I see the file on that, please?
I'm not sure if defense has had time to review, but also additionally, one of our main witnesses, the one that was undercover, is unavailable today to appear for that testimony. So I was going to ask the court if they would please reset this hearing so that we can have resolution. Because it is the new number one is the only allegation in the MTR.
And it happened less than a month ago.
Ms. Ferguson, reset this for a contested, what date?
I can do the January.
Is it possible a week, that's a very busy week, maybe the week after?
Thank you.
Thank you, Judge.
All right, thank you. Eddie Dacey. And counsel, I'm still waiting. If you want to call that attorney and find out where he is, I'll take your matter up.
Already hearing things. Come back here.
No,
We'll use our outside voices, Judge.
thank you. So where are we on discovery?
I believe we have almost all the discovery that we can expect. The one thing I don't believe I have are the medical records, but
All right, who's the prosecutor on this?
I'm sorry.
Dacey. Where are you?
Oh, it's.
No, he also has a family violence case as well.
I'm not, who we've been confirmed with.
mostly family violence.
All right. Well,
And not even today.
Yeah, I know. I was like,
All right,
Judge,
I apologize.
I had set a hearing on Monday.
Mhm.
I'd spoken with the doctor. The hearing that I'd set was to make a determination on whether Mr. Dacey needed to have his GPS. He has.
All right, have
he
you
was having-
stayed on this?
Yes, but I've also talked to the doctor and the doctor said that the issue resolved itself, so I dropped that setting. I'll let your clerk know. And
Okay.
we're still here today. Yesterday, I did file a motion to withdraw because I'm trying to retire at the end of this.
Okay,
So as far as discovery goes, I think I've got everything I need. The other attorney, if you were allow me to withdraw, would have everything they need.
And Your Honor, just so the record is clear, he does have an indicted CTD case that came out of our family violence case. Our family violence case is unindicted.
Mhm.
I don't expect it to be indicted for some time. We are waiting on labs.
all right. Sir, just have a seat. Just have a seat.
So I guess what I'll do is I'll talk to CTD and see if we can work something out.
Okay, all right, thank you. All right, Eric Simmons. Hello.
How you doing?
Oh, I'm doing okay. Counsel, you're on the other side. All right, today is final plea deadline date. Jury trial, or you all have reached an agreement?
Jury trial.
All right, how long do you expect this trial to last?
No more than 2 days. 3 days.
All right, Ms. Ferguson, I need a jury trial date, criminal trial, I'm sorry, family violence, 3 days.
I believe I'm in 2 days. March 24th.
All right, once you sign the reset form for March 24th, you'll be excused, and I'll need an acknowledgement of discovery done.
Okay, Judge.
All right, just have a seat.
Thank you, Judge.
Thank you. And Norma, I'm sorry, you said March 24th?
Yes, ma'am.
Antavius Cifuentes.
Present, Your Honor. Morning, Judge.
Good morning. Hello, why were you late?
I was late. I think, Judge, he stated that his name was not called initially, and then you brought it to the court's attention, and they went ahead and marked you down.
No, I called his name.
Oh, you didn't hear it then?
Mhm.
I said, Antavius Cifuentes, and you said we'll work on it.
Oh, she was talking, you were talking to the guy behind him, Judge.
Ah,
I think that's.
okay. So where are we on this case?
Yes, Judge, I was appointed on this last week. I did peruse the discovery and there is an IDR as well as a body cam that I cannot access at this time. So I did bring that to the attention of Mrs. Espinosa. So we're gonna work on getting that together. I did forget my portable drive. I apologize, so I could not get it today. But I'll get that soon. I'm sure Mrs. Espinosa, I think, can even put it on a disc for me, and then I can get that and to review before a potential next setting, Judge.
All right. And how old are you?
19.
19. All right. Make sure you stay in contact with your attorney. You understand?
Yes.
All right, Ms. Ferguson.
Yeah.
I need a reset for discovery 30 days.
20th.
That'll be fine, Your Honor.
All right, so we'll be back on January 20th.
Yes, ma'am.
Are you
Thank
in school? What are you doing?
For work,
Are you work?
I trade stocks.
I'm sorry, what?
Trade stocks.
Trade stocks? I hope that is being very lucrative for you.
It is.
Okay, all right. Good luck to you. Once you sign the reset form, you're excused.
Thank you.
All right, you're welcome.
Good day, ma'am.
You too.
I'll get to the reason.
All right, Henry Salazar. All right, so this is set for a contested.
Judge, it is set for a contested, so the defendant was indicted on a new charge that the state was intending to prove up. There are a couple of body worn cameras that were too big for defense counsel to pull. So she was gonna get us a drive, so that we can provide that to her. The other thing is that the defendant was recently, he did submit for urinalysis, and after conferring with probation, that has not been processed yet, and I would like to know the results of that, just to maybe we can come to an agreement, or maybe not. So I'm requesting if we could get a contested at a later date after we're able to provide the videos and then get the results of the urinalysis.
All right, Ms. Ferguson,
Yes, ma'am.
on this case, if you're, how much time? 30 days?
That should be sufficient.
All right, if you'll set this for a contested hearing in 30 days,
Yes, ma'am. I can do, January 22nd.
That should work. Let
all right, once you sign the reset form, you'll be excused. Thank you for dressing appropriately for court.
Yes.
Thank you.
Just have a seat. Your attorney will bring the reset form to you. Once you sign it, you'll be excused.
Thank you.
All right, thank you. All right, so,
Approach.
yes.
Okay, so I spoke to Mr. Dace. I looked him in the back because he's not well. He's hitting his breather machine, and so I don't want him to come in and have an episode. But
Yes.
we've spoke. I've introduced myself. I've got his information. I'll reach out to the state. I guess they're waiting, like you said, some labs and some ballistic reports or something.
Yes. All right, so Ms. Ferguson, on Daisy,
Yes, ma'am.
Mr. Bonk is going to be his new attorney.
Okay.
And then if you can give 45 days for discovery.
Do you still have the motions he filed on yeah, you
want?
No, if she still has them, I'm gonna ask her if she. Could we,
3 seconds.
that's fine.
Okay.
Could you use the motion he filed and deny his motion, but grant the waiving of the fees? So we don't have to refile something else?
Yes.
Okay.
And Judge, if it helps, I did talk with Ashley Jones, and the state is not opposed to waiving his fees on.
Oh, I always do that if it's clear that a person can't afford it.
Okay, thank you, Judge.
Fair enough.
All right, so this is the new attorney. Discovery is going to be set for February 2nd.
Okay.
And that's on your case as well, whether it's indicted or not. Okay.
Okay, Judge.
All right,
Thank you.
thank you.
Thank you. Okay.
Jonathan Dreamer.
Judge, apparently I've been informed, Mr. Dreamer, I guess they're looking for him.
No, I mean, he's in jail.
Yeah, apparently he's not here.
Oh, no, the bus broke down.
Oh, Bear County, that never happens.
And so that's why he's not here yet.
Okay.
But if you talk to the deputies, they'll give you an ETA.
I
just went down there. They haven't seen.
All right.
So just for, to catch the court up, PIC is handling the ag kidnapping and the multitude of new charges. And I got a big bunch of discovery I brought my hard drive over, but the one thing we are missing is there's an indication in the statement from the complainant that she had signed a written agreement designating the scope of their adventure together. And so obviously that's going to be necessary at trial for cross-examination to determine what the scope of that playtime activity would be.
So do you have the contract that they signed to enter into their contract?
Sarah was looking for it. The regular prosecutor.
Today, Judge, but I can write everything down that we need to get on it, and then.
Yeah, I talked to her as soon as I looked at the discovery and I saw the indication that the lady said, yeah, I may have signed a written agreement. Sarah was going to look for it because it's not contained in the discovery. And I don't know if the detective was overly thorough, because you'd figure if you, particularly on this case, that's going to be the key to whether or not there was actually a crime or just breach of contract.
All right, so you'll need to make sure, I'm gonna recall this in 20 days. And you'll need to make sure that any contract that was entered into between the two parties, search for it, and then the defense will need that.
Okay.
Yeah, it's my understanding that I think it was produced on this website that's indicated in the report.
Okay.
All right, Ms. Ferguson.
Yes, ma'am.
All right, on this case, he has two cases. I'm going to need this recalled in 20 days. And at that time, if there's a contract that's in existence between the parties, state you'll need to be turning that over, and you may need to go to that site to pull the contract.
Because I'm not going.
Okay, so,
January 8th.
all right, so we're going to recall it January 8th for discovery. And that's to turn over the contract to defense.
Okay.
And honestly, with regards to that site, I just have to imagine that everybody is not privy to those contracts. So people may need to release certain codes for somebody to obtain the contract.
Yeah, so that's going to be the issue, whether or not the detective asked the lady for it, or they got a subpoena.
Or maybe your client has the code.
Yeah.
The subpoena might get it done, but I don't know. We'll see.
Okay.
It'll be a doozy. All right, thank you, Judge.
Okay, thank you. And if I could have the parties on Adalia Solomon Sobs. All right, the court is calling 2025 CR 013374 State versus Adalia Sobs. Could I have parties announced for the record?
David Rodriguez for the defendant.
And are you Ms. Sobs?
Yes, sir. Yeah.
No problem. And I'm sorry, what page is Sobs on?
On page 14.
Thank you.
Fourth one down.
All right, counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Sobs, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Sobs, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Sobs, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 12 months in the state jail facility. There's a $1,500 fine, and the state is opposed to your application. Did you understand that to be the plea?
What?
All right, according to your plea bargain agreement, the state is asking that you be sentenced no more than 12 years in the state jail facility. Do you understand?
Yes, ma'am.
They are asking that your fine be $1,500. Do you understand?
Yes.
They don't want you to have probation. Do you understand?
I have to say so.
Now, here's the thing. Now is not the time to say anything. Now's the time to just answer the questions that I'm asking of you. Do you understand that the state is asking that you be sentenced anywhere from 180 days up to 1 year in the state jail facility? Do you understand?
Yes.
Do you understand that they're asking that your fine be assessed at $1,500? Do you understand that they don't want you to have probation? They want you sentenced to time at the state jail facility. Do you understand? Do you understand that to be your plea?
That they want, yes.
Defense is at the plea?
It is the plea.
State is at the plea? State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There have not.
Then how do you plea? Okay, why is everybody whispering today? I need everybody to speak up. All right, state, any evidence?
State offers states one attachment.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Counsel, if you would like this set for a PSI, then it'll be 8 to 12 weeks.
That's.
All right. I need a PSI date. All right, I'll get, Vashon, what date for a PSI? Oh, just give me a date that you would like and we'll make it happen.
May I have February 5th, Judge?
All right, we'll be back on February 5th.
Very good. Thank you.
All right, thank you. Michael Herrera.
I'll try to get hold of the.
All right, today is your plea deadline date.
Yes, ma'am.
So have you all reached an agreement or you want a jury trial?
We're gonna need a jury trial, Judge.
How long do you expect this trial to last?
2 days.
He's from that.
All right, I need a jury trial date, 2 days. Is this criminal trial division or family violence?
Family violence.
On page 14.
Norma, can you set this for the week of first week in January?
Judge, I don't know that I'll have enough time to prepare. I'm gonna need to get an investigator.
Okay, well, we'll see where we are.
I can do January 7th, Judge.
All right, January 7th.
Thank
Once you
Judge.
sign the reset form, you will be excused. And I need an acknowledgement of discovery done, please.
Yes.
And this is family violence.
Judge,
Yes.
sorry. The co-defendant is Mr. Herrera's wife, who is also on your docket, so
Yes.
just wanted to let you know, some consistency in the court dates might help.
Oh, no, it's gonna be the same, but nothing can be done until their attorney shows.
I understand.
Yeah.
I just want to let you know.
Okay, all right, thank you.
Thank you.
All right, thank you. Not acknowledgement of discovery, and it's set for trial on January 7th. All right, Wagner.
Good morning, Judge. That's me. We're set for a competency disposition in the magistrate court on Monday.
Okay.
but I conferred with the state.
And what are the results of the competency?
So they said he's competent.
Okay.
I'm gonna be very honest with you, Judge. I'm still deciding if I agree with that or not. But I'm gonna try to meet with him and make that final decision by Monday
Okay.
and see if I need to test that or just agree with it and move forward with the disposition on this case.
Ms. Ferguson,
Yes, ma'am.
on this case, Wagner,
Yes.
recall it for final discovery in January, 30 days.
Today, I could be the 22nd.
I think that's,
Thursday
I
or the
think,
20th.
I think both of those will work. If you just let me check real quick. You said which days?
The 20th or the 22nd?
Could we do the 22nd?
The 22nd?
Thank you.
What date?
The 22nd, January.
All right, see you then.
All right, sounds good, Judge.
Thank
Good to
you.
See you. Thank you.
All right, Jonathan Carter. All right, the court is calling 2025 CR 007350 State versus Jonathan Carter. Could I have parties announced for the record?
Jeffrey Wright for the state.
Caitlin Knowles for Mr. Carter.
All right, and excuse me, the other attorney, if you can come forward. And also for Mr. Carter, if you could state your name, please.
Kyle Simpson.
All right, have both parties, I'm sorry, defense counsels, have you received discovery from the state and did you review it with your client?
We
Yes,
have,
ma'am.
Your Honor, and we did.
All right, court will find that state is in compliance with discovery. Mr. Carter, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsels, do you waive the reading of the indictment?
We do.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the offense of publishing or threatening to publish intimate visual material as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? All right, why is everybody whispering today? All right, that's okay. It's like people are whispering for some reason. I can't hear. Court reporters having a hard time hearing. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsels, has your client been able to provide you with any defenses?
Yes, Your Honor.
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Yes, Your Honor.
Mr. Carter, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Just for a moment. Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the
No.
agreement, thank you. Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 100 hours community service restitution, TAP evaluation, The state has put zero tolerance. I don't do zero tolerance. You know, either you violate your probation or you didn't, and then I make decisions on that. A mental health evaluation, parenting classes, anger management class, BIP class, no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea. Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Judge.
I'm sorry, not the plea. Did you understand that those recommendations are recommendations from the state and the court does not have to follow those recommendations? And those are the recommendations that the court previously read which is the state is recommending 2 years. So I don't have to give you 2 years. I can give you more than 2 years. 100 hours of community service restitution. I can give you more than that. The mental health evaluation, parenting classes, anger management class, BIP class, and the no harmful or injurious contact. You understand that?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers State Exhibit 1 and attachments. Without objection.
All right. And
No
state,
objection.
thank you. And state, have you spoken with the complainant?
Yes, Judge, and she's here today.
All right. Mr. Carter, did you review the waiver and stipulations of testimony with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes,
Yes, Your Honor. We'll waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. So this, the offense as charged, right? Whenever you see that offense on paper, you know, it gives a certain impression. Our client was in the throes of custody issues. He understands that he made the wrong decision to take his anger out in that way, rather than, you know, addressing it in a healthy manner. Mr. Carter volunteers as a football coach at a local high school. He is a former NFL player, and he is giving his talents and giving back to the community in that way. He is fully committed to continuing that path. He is fully committed to working on himself, and this incident does not define him. He is remorseful, and he's ready to change under your supervision.
All right, why is there a request for BIPP? I'm sorry, you're not the attorney on this, but I mean, I understand that this is seen as a form of abuse, but isn't BIPP for physical?
Battery. Yes, Judge, and I can just imagine, because it's someone who was a spouse of his, and this is not just some random person, and so.
I mean, I'm not gonna order that. How old are you?
46.
All right, why are you threatening to send out videos?
I made a mistake.
No, you didn't make a mistake. You made a choice.
I made a choice. I made a bad choice. And didn't think why.
Like why? And why were you knocking on her door or knocking on her window? What were you expecting?
Talk about my daughter, but it didn't help at all.
Well, what time did you go to talk about your daughter? What time was it?
Late.
What does late mean?
So this time 10 o'clock, I think. Well,
all right, nobody's knocking on somebody's door at 10 p.m. to talk about their daughter or talk about their child. They're usually there for something else. Did you call her? And I see you called her and she blocked you.
Yes, ma'am.
All right, so it appears that she doesn't want you anymore. I don't know why people can't accept that. And it's not like you're a teenager. Even teenagers, when somebody doesn't want you anymore, you can move on. As my grandmother would say, cry on the inside. Don't let that person know they've broken your heart, and just move on.
Yes, ma'am.
I don't understand why you don't understand that.
If I may, I think context matters here.
Oh,
My understanding is that the complaining witness was withholding visitation from my client.
and he had no way to do it. A custody suit has ensued and they're working that out. But during that time, they were breaking up.
So why would he go over her house after 10? Why not go over there at lunchtime? Why not go over there during, daylight time?
I think he was frantic, Your Honor. And he understands,
Why
right?
not? I want to find out if he was frantic. He hasn't told me anything.
We had the wrong way.
No, but I mean, why go to her place at 10? And the reason why I'm asking you these questions, it's so I can determine whether or not all of these extra conditions that the state is asking, whether or not that's appropriate.
Because at the time I was allowed to come over there anytime I was so serious, and I thought we could go over there.
What do you mean you were allowed to come over at any time?
No, because I used to go over there like to see my daughter. I leave to go home by 8 before she go put in bed, and all of a sudden then she got mad at me, and then she blocked me, and I was just talking to her, and I just went over there, and I should have went over there.
Mhm.
That's when the custody thing came up then after the fact.
So what family members do you have in San Antonio?
None. I moved out here just for my daughter.
To co-parents.
To co-parent.
From Alabama.
Well, we was trying to get together. I bought a house here and we're not together, so I'm stuck in San Antonio. So I said, and I only got here about my daughter here. That's it. I don't have no family.
So how do you all discuss childcare issues? What is happening with that? Is it through the app?
Right now, we've been talking to each other on the phone, and my daughter got a watch, and I've been hanging out with her when she allowed me to see her. Taking me, supposed to be going to see the light show tonight, so if I've been contacting.
With the complainant and the daughter.
Right.
So they're amicable.
Both of us.
Well, here's the thing. People hang out with each other and then they think things are great. And then maybe they'll decide that they're going to get back together. You shouldn't do that because whatever issues y'all had previously, these same issues are there.
Judge, he also has a daughter that's 17 that is in the state championship as a wrestler in Alabama. She's already not committed, but she's been offered a full ride to the Naval Academy. So we'd ask that he be able to travel freely between Alabama and I guess Annapolis, Maryland. Should that be where she commits?
All right. So what I can tell parties, I don't know why people get in relationships and then they have this issue with the children where people are not letting people see each other, not letting people see their children. But this is what I can tell you. When a relationship is over, it's over. Don't try to get back in that relationship. You and the complainant are supposed to be adults and everybody's supposed to be putting their children first.
Yes, ma'am.
And when people hurt the mother of their child, the father of their child, just being petty, then you're hurting the child. Do you understand?
Yes, ma'am.
And I can tell you, until things were explained to me, I was close to giving you jail time as a condition. But now I'm able to see everything and the state was not asking for jail time as a condition.
Judge, again, context, complaining witness and my client went to the same school, Troy University, Alabama. And he played football for the school and she was an athletic trainer, correct?
Yeah, I've been on a lot.
So it's an on and off relationship for 20 some odd years. Is that right? 6 years.
It's been a while.
Then the baby came along and tried to do the right thing, moved to Texas to co-parent, and things happen.
All righty. This is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. The coaching that you do, are you paid for that?
No, ma'am.
Okay. So
I'm gonna get paid for it.
all right, so there's to be no there's to be no employment as a home health care provider with minors. There's to be 100 hours of community service restitution. Ms. Abrams, if you verify that he's actually coaching, that can count towards his community service hours. Field visits 1 time per month for 3 months. And the complainant is requesting the no harmful or injurious contact?
Yes, Judge, and the idea is for the child custody and transferring.
All right,
There-
there's, yes.
He has total and permanent disability with the NFL. And so he's not allowed to work for that.
He'll need to provide proof of that.
Okay.
All right, so proof of employment within 40 days or proof of inability to work. And the court will require an anger management class. And I'll require a parenting class. Probation, is there anything else? Oh, I'm sorry, I wrote it in, but I didn't say it. No harmful or injurious contact with the complainant. All right. Is there anything else that you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. If you complete everything early, the court will consider early termination.
And Judge, I may have not on it, but did you allow travel?
Miss Abrams? He's allowed to travel to
Alabama.
events with his other daughter. So he's allowed to travel to out of state. Because maybe they're gonna go to another wrestling tournament other than Alabama.
And is that just particular to his daughter, Your Honor, or can it be
Yes.
also, he has an elderly mother because that lives in Alabama, he helps care for, he's the only child that can care for her.
All right, you all will just need to approach on that. Your attorneys will need to turn that over to probation.
Thank you.
Okay.
Thank you.
Four. All right, Vashon, just go ahead and say he's allowed to travel out of state for his child and also for his mother. And there's to be UA upon return. So that'll be a UA within 24 hours. So if you leave and you come back, it'll be the UA the next business day. And you can either do UAs or either you can do the patch. The patch costs more, but with the patch, probation will just put a patch on you. You don't take it off, don't tamper with it, because that'll be a violation of your probation. They will pull it off and then they'll test it. All right. Did you review the trial court did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. We're off the records. They're saying they have a victim impact. Basically, what ends up happening is the complainant speaks to you. I require that everyone is respectful to each other, and usually the complainant will tell you their feelings on this offense. Do you understand?
Yes, ma'am.
Great, thank you. So if you'll stand over there, and the complainant will remain seated.
Oh, okay.
Yes. Nicholas Vaquera. All right, the court is calling 2025 CR 009909 State versus Nicholas Vaquera. Could I have parties announced for the record for the state
Rick Pena for the state of Texas.
defense?
Austin Hagee for Mr. Vaquera.
All right, and do you have the motion with
I
you?
do, Your Honor, here.
And are you Mr. Vaquera?
Yes, ma'am.
All right, the defense has filed a motion to remove GPS bond conditions. State, do you object?
Yes, we do object, Your Honor.
All right, you may proceed. Why does it need to be removed?
Your Honor, my client is currently expecting a child. His wife is 9 months pregnant. She's here, and I do intend to call her. She can provide some information on the support that she will need. In the alternative of completely removing GPS, we would ask for tracking only. if she does end up delivering the child in the middle of the night or water breaks, something like that. And he
Do you have an objection to tracking?
I do object to the track, and I thought we had an agreement last time real quick that his current conditions can be amended, so that he can attend any doctor's appointments that may still be remaining for his wife's pregnancy, as well as obviously go to the hospital with her on the day that she is to deliver.
The problem with that becomes GPS does their job well, and they can't know when something is maybe going to happen. Childbirth cannot be planned, unfortunately.
Oh, no, if there's a violation of a bond condition for GPS, it comes to me, they send me an email.
No, I understand, Judge, but you're normally not going to be checking that at 12 o'clock at night or on the weekend.
No,
And
it
if you-
comes to me and then I make a decision on whether or not to sign it. They don't like send it to somebody else because I'm not there.
Yeah.
And what I can tell you, Mr. Vaccaro, with regards to GPS, what ends up happening is when they file a GPS and they say there's a violation, the first thing that they do is they call you and they let you know, hey, where are you? We have a alert that you're not where you're supposed to be. So if, for example, and I'm not saying I'm going to deny council's motion, but if you were at the hospital and GPS doesn't show that you're supposed to be at the hospital, the GPS tracking is going to show that you're at the hospital. And then if you're at the hospital, normally they won't call because they'll see you're at the hospital. But if for some reason they feel like you should not be there, they will call you and you can say, my wife is giving birth. This is where I am. All right, but you can continue. Do you have witnesses?
I do have one witness, and I think the concern, Judge, becomes if the monitor starts to go off in the hospital. I don't know if the staff, such as the nurse and doctor, are going to feel comfortable with him having a GPS monitor ringing while they're trying to deliver the child. And will they let him stay in the room or not? And I can just see that becoming a traumatic event for his wife and him. And I don't think that's really necessary at this particular juncture of the case, considering he hasn't had any violations in well over a year. But I will call her to come stand. America Willis. So it doesn't have a support system to
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
America Willis,
All right, and how old are you, Miss Willis?
23.
All right, you may proceed.
Ms. Willis, are you currently expecting a child?
Yes.
Who's the father of that child?
Netflix for Kara.
And are y'all married?
Yes.
Okay. And when did you, well, we're going to get into that. Currently, where do you reside?
This is my mother.
Okay. And do you live with Mr. Becerra?
I can tell you all right now, nobody can hear anything that's being said.
Sorry.
I can't hear. The court reporter is struggling to hear. I don't know. Today, everybody seems to be whispering.
Yeah. So if you can please speak up so everybody can hear you, and we'll add the microphone, that might help. Where do you currently live?
I live with my mother.
Okay. And does Mr. Becerra live at that residence?
No.
Okay. Is that because there's not enough space at that residence for both of you?
Yes.
Okay. And also he has a bond condition of where he can and can't stay and when he can come and go. Are you aware that Mr. Becerra has a GPS bond condition?
Yes.
And you understand he has a monitor on?
Yes.
And it limits his movement? Okay. Right now, how many months pregnant are you?
9.
Do you have any other support system that can take you to the hospital?
Currently, no.
Do you have anybody else that can help you pick up formula?
No.
If you need help taking care of the child after the child is born, will you have anybody else that can be there to help you with that?
No.
And so Nick is really your sole provider for any sort of aftercare that you need after having the birth of the child.
Yes.
And as hard as they say, you do understand that some people do have traumatic births and that sometimes it has a recovery time.
Yes.
And it is possible that could happen here.
Mhm.
Okay. So are you asking the court that he either have tracking only or have this device removed so that he can help you during this time?
Yes.
Okay. Have you experienced him coming to a doctor appointment or trying to come to something and his monitor go off and start beeping or having issues with it? Okay. And does he normally get his appointments approved by the GPS officer usually? Or is that sometimes hit or miss?
It depends.
Okay.
We had one appointment.
Okay, one doctor's appointment
That he's gone to.
that he's been able to go to because he has to get it approved in advance. Okay. But if he doesn't get it approved or they don't respond to him, can he just go?
No.
So everything has to be approved in advance.
Yes.
And in your experience, are these GPS officers overworked?
Yes.
Objective relevance, Your Honor, on that one.
All right, that'll be overruled. You can answer.
Does it seem that they sometimes have a hard time responding?
Yes.
And they sometimes say, only email me, do not call me, or things of that nature. They have certain preferences.
From what I've heard, yes.
Okay. And so are you asking the court that you be able to have father of your child, my client, Mr. Vicara, at the birth and able to help you afterwards by getting tracking only or having the GPS device removed?
Yes.
And you understand, and I'm sure he understands as well, that if there is a violation, they can put him back on full house arrest if they want.
Yes.
Or remand him without bond if he violates in any way.
Yes.
Okay. And knowing that you're still asking that the court would put him on tracking only or remove the GPS device. Okay. Is there anything else that you would like to add that the court can use in making this decision? Thank you so much for your time. You can give me that back. And you can please go sit down.
No.
I have questions.
Oh, I'm sorry. Yeah, of course. Yeah, go ahead.
If I may, Your Honor?
Yes.
You said your name was Miss Willis?
Yes.
When did you first meet Mr. Vaquero?
2 years ago.
2 years ago. So that would be when you said you're 23, correct? So when you were 21, you met? And how soon after you met did you guys get married?
We got married. Then for the last years and probably over a year.
December, okay, so December 2024. Okay, and when did you first realize you were pregnant? April of this year, okay. As of right now, do you have any remaining, I believe they call them prenatal appointments?
I don't think you know, but we're doing Sunday.
I'm sorry?
I'm due on Sunday.
You're due on Sunday, okay. Sunday's your due date, so with that being said, you have like a hospital in mind that you plan to go to that day should baby come, what hospital is that? Methodist, okay. Are all those arrangements already made with that hospital for that day? Okay. And you said, or you testified earlier that Mr. Rickard doesn't live with you, correct? But who lives with you, I'm sorry? Okay, so in theory, your mother could help you out with the things Mr. Hagee was asking about as far as formula, diapers, etc., things for the baby?
He's pretty sick.
How is she sick?
She has cancer.
Oh, I'm sorry to hear that. I hope that your mother gets better. So I guess other than your mother, then it's just Mr. Vaquero? Okay. In your life, no other family support system, no cousins, aunts, uncles, father? Okay. I'll pass the witness, Your Honor.
Any further questions?
So you're a caregiver for your mother?
Yes.
Okay, so she doesn't have the ability to help you.
Mhm.
And Mr. Vicara doesn't have parents in his life that could help either. Grandparents that could come and be a caregiver for you or anything like that. They don't have the availability to do that. That's it, Your Honor. I have no
All
further
right, I
questions.
just have a few questions.
Sure. Go ahead.
Right. Before you started dating him, were you aware of these pending charges?
Yes, boss.
All right, thank you. All right, this is what the court is going to do. The defendant is allowed to attend all medical appointments involving his wife and his future child, and there's to be no unsupervised contact with minors. All right, thank you.
So does that mean, ask me a question.
Rafael Rodriguez.
President, comments, I lost track of the prosecutor.
Oh, that's okay. Where's your, Mr. Rodriguez?
By the way, good morning, Your Honor.
Good morning. How's it going?
Good, good.
All right. Did the state tender an offer?
Oh, yes, Your Honor, we're in the process of attempting to negotiate a pretrial diversion protocol.
All right. State. On Rafael Rodriguez, is this going to be a PTD?
I haven't been, that's not sure.
He's on page 5, number 3.
Oh, Rafael Rodriguez?
Yes.
Do you prefer anybody was first?
Yes, the gentleman in charge of elderly crime.
Oh, Hunter.
He was here a while ago now.
This is Hunter's case, Your Honor. Let me text him.
Okay.
You want us to back up?
Yeah, just have a seat and I'll call you back up. And Melissa, if you can just text him to see if they have come to an agreement on a PTD. Kevin Williams. All right, have you received an offer?
We received an offer today, Your Honor.
All right.
Waiting on a little bit of additional discovery.
All right, Ms. Ferguson. Set this for a plea deadline date. All right, this is going to be set for a plea deadline date in January. And I will set you for January 22nd. All right, once you received the reset form, you sign it, you'll be excused.
Yes,
And that will be your plea deadline date.
yes, sir.
All right, thank you. Yes.
Hunter said that he is going to consult the complainant and then he will let him know if he's gonna give him a TD.
All right. And what is your client's name?
Rodriguez, Your Honor, Rafael Rodriguez.
Let me just find him again on the docket sheet. Thank you. Mr. Rodriguez, if you'll come forward. All right, Mr. Rodriguez. I'm going to recall your case in January, and it's for the state to make the decision on whether or not they're going to proceed with a PTD for you. All right, so I'm going to recall this for January 15th. All right, once you sign the reset form, you'll be excused. So just have a seat, be patient.
Thank you, Your Honor.
Thank you. All right, the court is calling 2024 CR 2214 State versus Shepherd, Eric Avila Jepson. Can I have parties announced?
Melissa Albin for the state.
Pat Hancock and Mr. Jepson.
And are you Mr. Jepson?
Yes, Your Honor.
Defense has filed a motion asking that bond be set in your case. Was there not a bond previously set?
There was, Your Honor. He has an MTR filed, so his bond, he was remanded.
All right, does anyone have a copy of the MTR?
Mr. Hancock had one, Your Honor.
All right, there's a request for bond to be set. And it's the court's understanding that you all have reached an agreement?
It is, Judge. I've conferred. We've reached an agreement to set the bond at $30,000 if that's okay with the court.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Shepherd Jepson.
All right, since you've been placed on probation, have you suffered any type of mental health issues?
Oh, no, I have a they waived medical marijuana for me for I got a gunshot in my leg.
All right, so have you ever seen a psychiatrist in the past?
No, but I got the gunshot regarding PTSD.
All right. And have you ever used any type of drugs in the past?
No.
All right. The court will follow your agreement. The court will set your bond at $30,000. There's to be GPS, waive fees, and it will be full GPS. Is there anything else with regards to this hearing? All right, we can go off the record. We need to have this motion set. Ms. Ferguson?
She's not here, Judge.
Yeah, it's not. All righty. Ms. Abrams,
Yes, Judge.
when would you like this set for a contested MTR? And if it's not contested, it's not contested. And
Judge, the first, January is fine.
all right, this is going to be set for contested January 7th. All right. Once you sign the reset form, they will transport you and they'll place this in the system.
Thank you, Judge.
Thank you. Who's here on Ruben Villarreal? All righty.
Yes, ma'am.
All right. Thank you.
And Judge, before we do this, I have the paper copy of the judgments. I didn't want to scan them as to not break the seal of them being certified. So I.
All right.
totally
Is there going to be any objection to that, defense? You're on mute.
No objections, Your Honor.
All right, the court is calling 2025 CR 009602, State versus Ruben Villarreal. Can I have parties announced for the record for the state?
Lauren Espinoza.
Defense?
Alma Benavides for Mr. Villarreal.
And are you Mr. Villarreal?
Yes, Your Honor.
All right, did you review the document entitled Defendant's Consent to Appear by Video with your attorney? Did you understand it and electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Did you review the discovery? I'm sorry, defense, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Villarreal, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State moves to waive the enhancement allegation and proceed solely on count one.
No objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with theft of property, $2,500 or more as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No, Your Honor. Well, yes. I
All
don't
right,
want
so
to,
here's the thing. You have a right to jury trial. Do you understand?
yeah, I don't want to do jury trial.
All right, so you understand that by entering into this plea, you're giving up all of the rights that I've explained to you, the right to jury trial, the right for you or your attorney to confront any witnesses against you, and the right to remain silent. Did you
Yes,
understand?
Your Honor. Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Villarreal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone
No.
promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargaining agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement, there's an $800 fine. Punishments to be assessed at 51 days in the Bexar County Jail under 1244. The state will take in consideration 2025 CR 010849. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right. You're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the, and outside the agreement, the state is requesting that you have no contact with HEB at 10660 Calabria Road, 78251. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
We've reviewed them, Your Honor. No objections.
right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the plea bargain, and we wanted the court to take note that Mr. Villarreal was taken into custody on October 29th of this year. And he has been in continuous custody at the Denton County Jail.
Okay. All right, is there anything else?
Nothing further, Your Honor.
All right, the court will sentence you to 51 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Take in consideration 2025 CR 010849, and there's to be no contact with HEB. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Good luck to you, sir. Stop stealing. Otherwise, you're going to find yourself living in the jail or the prison, okay?
Yes, Your Honor. Thank you, and Merry Christmas.
Oh, Merry Christmas to you too.
Thank you.
Thank you, Attorney Benavides.
Thank you, Judge. May I be excused?
Yes.
Thank you.
It's on Mr. Rios. I put them, put
No,
myself on
I'm
there.
sorry, Rose Padilla
Oh.
first. That's okay.
But yeah, yes,
Yes.
we have, I think we have reached an agreement to, we're gonna plead true to one of the,
All right. Are you all ready to come up then?
yes.
All right, the court is calling 2015 CR 3473 State versus Rose Padilla. Can I have parties announced?
Ashley Jones for the state.
Robert Valdez for Rose Padilla, Your Honor.
And are you Rose Padilla? All right. My understanding is that you wish to change your plea to true on one of the allegations. You need to speak up. All right, state if you'll read the allegation.
Yes, Your Honor. Apologize for 1 moment. Violation of condition number 23 in Bexar County, Texas. The defendant Rose Padilla did then and there fail to make payments of $100 every 2 weeks in violation of condition number 23.
How do you plead to that, true or not true? All right, did you understand by pleading true to violation of condition number 23, the court could find it true, grant the motion, sentence you to 20 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 23? Court will find violation of condition number 23 true. What is the state requesting?
Your Honor, along with probation's recommendation, the state is requesting that the court grant the motion to enter adjudication of guilt, revoke the defendant, and place her on probation or community supervision for 10 years.
Well, no, is this an aggravated assault with a deadly weapon? Or is this, I think this is aggravated assault with a
Let
deadly
me
weapon.
check and see what
So-
it led to. I apologize. Can we step back for a moment?
Sure, so what yeah. Edward Rios. All right, state, were you able to tender an offer?
Yes, Your Honor.
All right, I need an acknowledgement of discovery done
Yes.
before you leave here today. And Ms. Ferguson, I need a plea deadline date.
You know, we want. Sometime
Uh,
in January.
Yes.
I can do January 13th.
All right, January 13th is your plea deadline date. You need to let the court whether you've reached an agreement after that. If you have not reached an agreement, your next setting will be jury trial, and the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, sir.
All right, thank you.
Thank you, ma'am.
Yes.
She's on page 14 at the bottom. Jeff.
All right, counsel, your case is coming back for,
Your Honor, yes, her and her husband are charged with the same offense, Judge. I believe the court's already set her husband for January 7th trial date. I have a sentencing hearing in Medina County that morning. And I've been talking, we're not anticipating severing this. I've been talking with co-counsel, or her husband's counsel. She wants to approach on a motion for an investigator and get an investigator on this. I just want to tell you where she's coming from on this. I've spoken and conferred with the state. He's got to get with his chief in order to determine if what we've discussed is kosher and copacetic with the district attorney's office.
so y'all have to have that worked out by January 7th.
Yes, Your Honor, but what do I do with the conflict in Medina County? I'm already set on a felony sentencing.
I would suggest coming here.
All right, I'll see what the district court judge wants out there.
All right.
That setting, I just want to apprise the court.
No, I appreciate that.
That setting was made, we had an MTR, the sentencing hearing. That setting was already in October, so I don't know what Medina County is
Okay.
going to want to say.
We'll see what happens.
Yes, Judge.
All
I
right, thank
appreciate it.
you.
Thank you, Your Honor. Thank you for your time. I have one more case. I'll be back.
Sure.
After
All right, thank you. I'm sorry, Amanda Farias.
Thank you.
Court is calling 2025 CR 006129. State versus Amanda Lynn Farias. Could I have parties announced?
Rick Pena for the state of Texas.
Joseph States in for Monica Godetto.
And are you Miss Farias? All right. Counsel, do you want to place on the record your representation of her?
It's a retained case. Monica is retained on this one. I work for Monica Godetto. Miss Farias, do I have permission to do this in front of Judge Boyd today?
Yes.
All right. Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Farias, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state, we'll be proceeding on count 1, paragraph B. We will waive paragraph A.
Any
No.
objection?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Oh, no contest.
You don't want to go to jury trial.
No.
You worked the deal out with the state. You wanted the judge to follow the deal.
Correct.
All right, so I want you to hear what I'm saying and internalize what I'm saying.
Okay.
You have a right to a jury trial. Do you understand?
Yes.
Do you want a jury trial? You want to enter this plea?
And then plea.
All right, you have a right for your attorney to cross-examine witnesses that the state calls, or you can cross-examine them yourself. Do you want to do that, or you want to enter into a plea?
And then to plea.
You have a right to remain silent. Do you want to remain silent? Do you want to give up that right, or do you want to enter into this plea?
And then to plea.
All right. Court will find that, just one second. All right, did you understand if I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Farias, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
I'm sorry, if you're not a US citizen, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's to be no contact with Oscar Castro, Yemi, Vanessa Bayo, Mondragon, Jesus Leyva, and the address of. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There be 200 hours of community service restitution, the BIP course, TAP evaluation, follow our recommendations, and MRT. Is there a affirmative finding that's being requested in this case?
Per the code, this charge doesn't come with an affirmative finding, Your Honor.
All right.
It's for Title V offenses only, and burglary of habitation does not.
All right.
fall under
Well,
Title
I'll
V.
read the facts and we will see.
Yes, Your Honor.
All right. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in paragraph B, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. At this time, state offers into evidence. It's Exhibit 1 with all attachments.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Our client's remorseful that this had happened. What's not in your, the stipulations, not to your knowledge, is that there was some abuse, possible molestation from the complainant against her child. And that led to this event.
Well, have there been charges filed for that allegation?
Not to my knowledge, Your Honor.
Any evidence presented to anybody for that?
This is the first time I'm hearing about it.
Okay, all right, you may proceed.
The client is employed, self-employed, does meal prep. There's a $1,500 fine. However, she may not have consistent income. I know this is for 7 years. I was hoping that the fine could be probated. She does do not professional home health care, like not a caregiver per se, but she does have to be around other people in a sense of making sure somebody doesn't fall over. If somebody needs something, she may help them. We're under the impression that this was not the affirmative finding of family violence. I had advised her that it likely would be imposed. And I would hope that you would follow the plea bargain agreement as written.
All right, so why were you over at that location? Because it appears from reading the stipulations that you were not invited.
Correct. Well, I was informed that he was there by him. This was ongoing abuse that I had been through with him. He would stalk me. He, would find where I was. And that night I was with my friends And he was telling me that he was gonna come looking for me and that he was gonna find me. Anyways, it led on to the next morning. He was still contacting me. He told me he was there. I was telling him to leave me alone. Long story short, we ended up getting into it, over the phone. So I went over there to where he was at. And that's how I ended up there.
I don't understand that. I don't understand why you would go to a location. Your attorney is saying you're in fear of him, but you go to the location. And then did you see the photos?
Yes, ma'am. And he's currently out. He was guilty of putting his hands on my son and myself as well. He's out right now. I think deferred. I don't know. I couldn't tell you the legalities of that, but and that wasn't his only time. After I was arrested with this, he came to my house looking for me again with a gun and put it to my head. And because there was a restraining order, he had one on me. I ended up getting arrested. And so this is, even me on house arrest, he was still messing with me. So I understand that I wasn't supposed to be there or I went looking for it, but I think that just me being, provoked and going through what I was going through with him, I snapped, I guess.
Well, if he's on probation, shouldn't he have a no contact order as well?
Well, I believe that was all done prior to this taking place. His own separate case that he was placed on deferred was completed prior to this.
So he's completed probation.
He's not completed, he's on deferred at this time.
All right, so there should be a no contact order. Is that out of this court?
I don't believe so, no, it's in a different court.
Oh, okay. Well, I would have ordered a no contact, so maybe somebody should let probation know to reach out so there can be no contact.
That's right.
Do you all have children together?
No, ma'am.
All right, so there's no reason to have any contact with him.
Yes, ma'am.
Court is going to sentence you to 7 years deferred adjudication. There's a $1,500 fine that will be probated. There's to be no contact with Oscar Castro, Yemi, Vanessa, and Miss Abrams. That's Yemmi, Vanessa, Bello, Mondragon, Mondragon, Jesus Leva, Levya, and the BIPP course, TAP evaluation out of custody, follow recommendations. 200 hours community service restitution. I'm going to order the BIPP course. Once that's completed, 100 hours be deemed satisfied. The MRT course, once that's completed, 100 hours be deemed satisfied. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue where he's bothering you, you need to let probation know. And maybe you can see if their probation officer can recommend that as a part of his conditions of probation, that he has no contact with you. And then if he were, that would be a violation of his probation. My understanding, his case is not out of this court. Otherwise, he would have had a no contact order. All right, good luck to you.
Judge,
You're welcome.
just one clarification. The meal prep that she does is not significant. She does the side thing of helping others where it's not in a.
I mean, she's just
legal
doing meal prep and dropping it off.
She may assist somebody with in the house movements, not make sure they don't fall over. She is not a nurse. She's not licensed. She's not a home health care provider in her sense.
If she's doing that for people, I'm assuming she has regular people that she does that for. Am I correct?
Yes.
You will have to get a letter from that person or their family stating that they're aware that you're on probation for this and they have no concerns with your providing that service.
Okay.
All right, thank you.
Thank you, Judge.
Yes.
This is a resumption of the motion to suppress hearing.
Yes. Can I see the file on scene?
Yes, ma'am.
All right, so with regards to this, the court had heard the evidence in this case. Is there any remaining argument from either parties?
Yes. Just from the defense.
Oh, well, let me go on the record if you have remaining argument. I was just trying to see where we are. The court is calling 2025 CR 010203 State versus Fabian Singh. And if I could have parties announced for the record for the state.
Farmer for the defendant.
And are you Mr. Singh? All right, we had a motion to suppress hearing. The court heard this case, the motion to suppress at least on I think December 8th or December 9th. Is that correct?
Something like that,
Yes, okay. And we're here for the court to make its ruling. And I know at that hearing, there were certain things that both parties stipulated to and agreed upon. All right, States has informed the court that they have no further argument. Defense, it's your motion. Do you have further argument?
Yes, Judge. Focus in this case is on the search of the defendant. The court will recall that officers responded to a welfare check call where the defendant was initially seen on the roof of a parking garage. When the officers encountered the defendant, he was on the sidewalk. They detained him and put him in handcuffs. The officers testified that there was no evidence that the defendant was suicidal. And in fact, the incident detail report indicated that the individual on top of the parking garage was not wanting to jump. However, the aggressive nature in which the officers approached the defendant, they immediately grabbed his arms, put him in handcuffs, and started patting him down. And they went beyond the initial pat down into the pocket of his hoodie and found a bottle of twisted tea. The pat down is legally allowed for search for weapons, not for alcohol. There was no indication, according to the officer's testimony, that the defendant was intoxicated at the time of the pat down for weapons. It's clear from the video that they just immediately went into his pocket for that can of twisted tea. There was no open container at all found. There's no indication of intoxication. So it's our position that from the very beginning, their intent was to fully search the defendant and find out what he had on his person, well beyond what was necessary for their safety.
All right. So, Mr. Singh, I want you to know that I've heard all of the evidence that's been presented to the court. My job is merely to listen to the evidence that's presented on motions to suppress, then make a decision based upon the evidence that's presented to the court. Do you understand? And the reason why I wanted this brought back is because I always, even though I say I know the law, which I do, I always like to make sure there isn't something out there that's brand new that maybe somebody, some appellate court just ruled on yesterday, right? I remember and I recall that I did ask parties if there was any case law that said that someone could not be arrested or was not allowed to be arrested for a Class C misdemeanor, to bring that to the court. And I have not received any emails to that effect. So the court will make its ruling. The court will deny the motion to suppress. And counsel, we're off the record. Counsel, do you have all the discovery in this case?
Yes, ma'am.
And state, were you able to tender an offer?
Prior.
Okay. How old are you? All right, Ms. Ferguson,
Yes, ma'am.
if you can bring this back in 30 days for a plea deadline date.
I can do January 22nd, Judge.
All right, we'll come back on January 22nd. Because of your age, I want you to have a chance to internalize everything that your attorney is going to tell you and think about the consequences or the potential consequences on either decision you make. All right, thank you. And thank you for always dressing appropriately for court. Once you sign the reset form, you'll be excused. All right, Rose Padilla, that's who you're already on?
Yes, Judge.
All right, come forward.
Judge, we thought, we thought we had an agreement, but since and the only reason we fled through is because we thought we had an agreement, but since apparently that's not the case, so we'd like to withdraw that agreement.
Okay.
I know, that you guys here.
All right, sure. Her plea of not true will stand for violations 10, 21, and 23. And you all come back here for a contested hearing.
When do we come back?
Norma, when can we fit them in for a contested hearing?
I can do the January 7th.
All right, January 7th will be your contested hearing.
Thank you, Judge.
Thank you.
Judge, I'm sorry, does the number 23 of not true still stand or?
They're asking that that plea of true be changed to not true. Yes,
Thank you.
And who is this?
it is Rose Padilla. No,
No.
that's not gonna happen.
She's gonna have to be in person.
I'm sorry.
No, all witnesses need to be in person.
Oh, even probation.
Yes,
Your Honor,
yes.
with regards to Ms. Ruiz, just a quick announcement.
Mhm.
The evaluation was
Oh,
done.
just 1 second. Let me have to pull it into Odyssey.
Oh, yes, of course.
All right, yes.
So Judge, she did have the evaluation scheduled for competency. It was conducted on December the 3rd. The magistrate court setting has a setting for December the 12th, Judge, for the evaluators. Report that's due, so we can see where we're at in competency. I believe there was an issue regarding transport this morning, requesting respectfully a recess after after January the 12th of 2026 for status of the competency.
All right, Norma,
Yes, ma'am.
I need a reset date for status on competency eval after the 12th.
January?
Yes.
Yes, I can do the 26th, Judge.
All right.
Perfect. I get that date down. Thank you.
All right, thank you. Valderis. All right, have you all reached an agreement?
No, Your Honor, the plea offer has been rejected.
Okay, Norm, I need a jury trial date. How long will this last?
I apologize, Your Honor. I would expect at least 3 days for the state's cases.
All right, 3 days, Ms. Ferguson.
Yes, ma'am, I can do March 24th.
All right, your jury trial date is going to be March 24th. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have the plea open to the court. Do you understand?
Yes.
All right, just have a seat,
We
counsel.
also have one more matter.
Yes.
We were asking the court to consider modifying his bond condition from full house arrest to partial house arrest or tracking only.
All right, have you all filed a motion?
We have.
They have, Your Honor, the state doesn't have an objection upon proof of employment and verification of employment hours to pretrial services.
Okay.
To modify it to GPS parcel. We would object to tracking.
We would ask the court to allow him to go out and look for work, Judge.
Well, nowadays, your employment, you do it online. So,
He's been doing that. Yes. He has tried.
all right. So the court will allow employment, partial GPS for employment only with proof of employment and your work schedule.
Just for clarity, Judge, he needs to find a job first before he can.
He needs to, I mean, he can do it online.
Yeah, Judge, he's been trying.
Okay.
Okay.
All right, and I need from the parties, an acknowledgement of discovery signed and, completed, and I'll sign it. All right, thank you.
Stepped out last week.
Thank you.
Thank you, Jim.
Thank you.
Happy holidays.
Oh, you too. Good afternoon. How's it going?
Good, good. Let's see.
All right, today is plea deadline date, and I'm assuming you want your jury trial?
Yes, Your Honor.
All right, Ms. Ferguson, I need a jury trial date. How long do y'all expect this trial to last?
3 days.
All right, jury trial date, criminal trial division, 3 days.
Family violence.
I'm sorry, family violence. Thank you. All right, March 24th.
Thank you, Your Honor.
And Ms. Ferguson, Mr. Davidson is requesting that Mr. Porter be appointed as the second chair. All right, thank you.
Thank you, Your Honor.
You're welcome. Oh, and counsel, you'll need to do a clothing exchange with him. And according to the jail's rules now, it needs to be done 72 hours in advance.
Okay.
Not more than 72 hours in advance and not less than 72 hours in advance. All right, thank you. Stephen Lamone. Are there any applications in this case?
Yes, Your Honor, for community supervision.
All right, Ms. Abrams, application. And he is on page 3. Court is calling 2025 CR 007431, State versus Stephen Lamone. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Renee Munoz on behalf of Mr. Limon.
All right, just one. So everyone in the box, y'all need to whisper. I would appreciate it if y'all would whisper in the box, and then when you're before me, don't whisper. All right, we're back on the record. And are you Stephen Lamone?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
That is correct, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lamone, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Lamone, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Mr. Limon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison, $0 fine, no application for deferred adjudication. State recommends community supervision. There's to be restitution to Trinity Key in the amount of $1,806.94. Ignition interlock for half the term.
Or an affidavit of non-driving.
Thank you.
I believe the defendant may not have a license.
Okay. Or an affidavit of non-driving. And what I can tell you, the court will add to that, no access to any vehicles.
Yes, Your Honor.
And a 2-year driver's license suspension. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours community service restitution, 10 days in the Bexar County Jail as a condition, participation in successful completion of VTC and inpatient treatment through VTC, DWI education and victim impact panel. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
States one in attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, if you may.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Limon has some root issues relating to substance use, Judge. All of his previous cases have been DWIs. He has not been afforded in those other DWIs the chance for treatment to get a handle on his issues, Judge. He was screened indeed eligible for Veterans Treatment Court. It's a very intensive program, which I believe Mr. Limon would benefit from, being that his military service and the issue he incurred because of his military service are tied with the issues he's currently dealing with now in terms of dependency issues, Judge. So we're respectfully requesting this honorable court follow the negotiated plea bargain agreement for probation with the condition of Veteran Treatment Court, Judge. Furthermore, if the court would consider in terms of the 200 community service hours, if he does AA and A classes, he may be afforded the opportunity to work his community service hours through the use of those meetings. And if the honorable court sees fit, he has been in custody pending the resolution of this matter. If he could be granted the 10 days Bexar County Jail, being the time he did upfront in relation to this case, Judge. Furthermore, he can reside with his mother at her address. And we're requesting this honorable court sees fit for him to be on full house arrest GPS, no access to any vehicles, and that way BTC can set him up with treatments, hopefully at an inpatient facility to get a handle on it.
All right. Ms. Abrams, are you ready? Okay. All right, this is what the court is going to do. There's to be a referral to VTC. My understanding, he's already been accepted.
That's correct, Judge.
All right. So instead of referral, I'm going to order VTC. There's to be 10 days in the Bexar County Jail as a condition of probation. Once you are placed on probation, your case will be transferred to the Veterans Treatment Court. And if they make the decision that you're not to serve the 10 days, then they can make that decision. The reason why I'm doing that is because if they want inpatient treatment, they may transfer you from the jail and just have someone to pick you up to take you to the inpatient treatment facility. Regular reporting by Zoom or in person, regular random UAs, ignition interlock for half the term, or he can provide an affidavit of non-driving and no access to motor vehicles. There's to be 2-year license suspension, 200 hours of community service restitution. I'm going to allow him to deduct an hour from those community service restitution hours for every sober support meeting he completes. DWI education course, DWI intervention, victim impact panel live, field visits 1 time per month until further notice, full GPS, waive fees. There's to be restitution of $1,806.94 to Trinity Key. Probation, is there any, and there's to be 8 years in the prison, suspended and probated for 5 years. And there's a $0 fine. Probation, is there anything else? No, he's already been accepted into Veterans Treatment Court, so they'll take care of that. All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, Veterans Treatment Program, that's a good program for you, right? If you successfully complete everything, when you graduate, if I'm in town, you let me know you're graduating, I'll show up for your graduation.
Thank you.
Okay. So which branch did you serve in?
Marine Corps.
Okay, well, you can do this, all right? If I didn't think you could do this, I would have read that report, and you know what I would have said? I would have said, I'm not following this agreement. So I know you can do it. The state wants you to be successful. Your attorney wants you to be successful. Even though your case is going to be transferred to them, and they'll be in charge of whatever conditions they set for you. If there's anything else you need, you can always come back here if I'm here, all right? All right, good luck to you. You're welcome. Thank you. And Renee, if you let VTC know that if they don't want him to do 10 days, it's completely up to them.
Yes, Judge, I'll update them that the probation is granted at that condition. I'll make that request. Thank you for reminding me.
All right, thank you. Ruben Cancino. All right, so what is happening with this case?
We're asking for a 30-day reset, Judge. This is first setting. We have an offer good for 30 days.
Okay.
In the last couple of days, have got notice of additional discovery. We would that come back in 30 days. Like I said, we've got an offer available, so.
Right, and how do you pronounce your last name?
Cancino, ma'am.
Cancino.
Yes, ma'am.
Thank you.
Cancino.
Cancino.
Yes.
All right, Cancino. All right, I can only say it if I do this, Cancino. All right. Can I have 30 days for a plea deadline date?
January 22nd.
All right, we'll be back on January 22nd. If your attorney wants you brought back sooner, he can let us know. We'll place you on the docket sooner. Thank you.
Thank you, Judge.
Vicente Bravo. Hello, and I know you were recently appointed.
Yes, Judge.
And do you need a reset for discovery?
Yes, ma'am.
All right, and I need a 30-day reset for discovery.
Miss,
I know. All right, this is what we're going to call it for. We'll recall you for January 22nd.
Okay, thank you, Judge.
Thank you. Once you sign the reset form, you'll be excused.
Thank you.
You're welcome. Thank you in just a moment, sir. Who's here on Richard Cantu?
no, it's
Richard.
Cantu.
Sorry.
I think that's okay. I thought there were going to be two people on this. All right, are you all ready to proceed on the NTR?
Yes, Your Honor.
Court is calling 2021 CR 11554, State versus Richard Cantu. Can I have parties announced for the record for the state?
Shots weather for Mr. Cantu.
And are you Mr. Cantu?
Sure.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it? Are you the same Richard Cantu as placed on deferred adjudication in 2021 CR 11554 for the offense of obstruction or retaliation on September 16, 2024 for a period of 3 years? Is that you?
Yeah.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Richard Cantu did then and there fail to report to the supervision officer as directed for the months of August, September 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We would abandon the remainder.
Any objections to the waivers? Did you understand by pleading true to violation of condition 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
True.
No, are you pleading true to number 4? Do you understand? No. Listen to me. Are you pleading true to violation of condition number 4? Yes or no?
No.
Don't know what I mean.
Oh, so this is what it means. The state is saying that you did not report. Do you understand that?
Yes.
Did you report?
No, I couldn't find the.
Nope. I just want you to answer my questions. All right. So you have just pled true to the fact that you didn't report. Do you understand that? Now, whatever agreement you've worked out with the state, I don't have to follow that. Do you understand? I can send you to prison for 10 years. Do you understand? So knowing that I can send you to prison for 10 years and up to a $10,000 fine, do you still want to plead true? Yes or no?
No.
All right, he doesn't want to plead true.
True for the probation office, I could not find the probation office. Yeah.
All right, so here's the thing. This is his second motion to revoke. I know he know what's going on here. So I'm going to explain it to you again. And if you wanted to proceed with saying yes, no, not answer my questions, we can do that. And this will be recalled for a contested hearing. The state will bring in a probation officer or whatever witnesses they need. Do you understand?
Yeah.
Now,
I could not. find
now listen to me. Are you pleading true to not reporting, yes or no?
No.
All right, so we need a contested hearing. All right. What date for a contested hearing? Failure to report.
I can do the 7th
Do you want to do the 7th
or the 9th.
or the 9th? Now it's up to you. If you want to bring it back for another day, that's fine.
We do second.
All right.
15th.
All right, we'll see you back on the 15th. The state will call whatever witnesses they need to call to seek to prove the failure to report. And what I can tell you on failure to reports, usually the person that needs to be called is the probation officer. And that probation officer is going to come in and say, either you reported or you did not.
I did not report. So I know I didn't report to nobody when I got released those 3 times.
So I don't understand why you're not asking my questions.
But to be saying, yes, I did not see no one, or no, I never went into the door. I'm saying that I never went to see the probation officer because I never saw him. I never got reported to see him. I never got his address or his phone number to see. Yes, I want to move forward with my case. I want to take it to. I want to take it all the way, like guilty and not guilty. I plead guilty. I plead no contest also. But I never saw my probation officer when I got released. I never had ever seen.
You want to talk to him some more? And Mr. Delio is still not out here? Okay. Hi.
Good morning, Judge. Or, not morning.
Are you all ready to proceed on this motion to revoke?
Yes, Judge.
All right, court is calling 2022 CR 1107 State versus Angel Cantu. Could I have parties announced?
Rick Pena for the state of Texas.
Warren Gary for Angel Cantu.
And are you Angel Cantu?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Angel Antonio Cantu who's placed on deferred adjudication in 2022 CR 1107 for the offense of indecency with a child's sexual contact on August 25th, 2022 for a period of 10 years? Is that you?
Yes.
State?
Yes, Your Honor. Violation condition number 13A. On or about the 11th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, did then and there fail to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to having internet identifiers on Discord, Kick, and other social media platforms. Violation of condition number 13.
How do you plead to that? True or not true?
Sure.
Violation condition number 13B. On or about the 16th day of September 2025 in Ventura County, Texas, the defendant, Angel Antonio Cantu, failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered sex offender treatment program, in that the defendant failed to progress toward reasonable treatment goals and was terminated from treatment in violation condition number 13B.
How do you plead to that, true or not true?
Violation condition number 13JA. On or about the 11th day of September 2025 in Bear County, Texas, the defendant, Angel Antonio Cantu, then and there failed to comply with the instructions of the Bear County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to accessing the internet on an unmonitored device in violation of condition number 13JA.
How do you plead to that, true or not true?
True. Violation condition number 13L. On or about the 11th day of
Let me just stop you all. Are you all doing 13L but not 13F?
13F and 19 are going to be waived by the state.
Okay. Do you really need 13L?
You can waive 13L as well.
No objection, Judge.
All right, did you understand by pleading true to 13A, 13B, 13JA, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to 13A, 13B, and 13JF?
Yes, Your Honor.
Court will find 13A, 13B, and 13JF true. Is there a proposed agreement?
There is, Your Honor. That is to grant the state's motion, revoke the defendant's probation, adjudicate him guilty, and sentence the defendant to 8 years in prison.
All right. Why should I follow this?
So Judge, Mr. Cantu has, so these allegations arrive from Mr. Cantu's own statement. So he was self-disclosing of these things during the process of which he was getting treatment for under the sex offenders program. He had been asked by his counselor, through the various ways they go through counseling, how are you doing? What's going on? He self-reported these incidences. The thing that what I understand from how I've looked at this case is that my client has had struggles with doing probation. I think ultimately probation is good because it helps us find these issues where we have problems that kind of relapse up. I think given that Mr. Cantu has indicated, we're here today because he's not hiding anything. He's not proud of what he did, and he has indicated to me that he understands that this is, it's not good, and he, shouldn't have been doing it in the first place, Judge.
So has he had contact with the complainant?
Judge, it is my understanding that he has not. I do have the mother of the complainant here is present, if you would like us to call her, Judge.
I mean, well, you talked to her, she's saying that he hasn't had contact?
That is what she said, Judge, and I understand that's only her statement.
All right. And how old is the complainant?
I'm gonna get her.
How old is the complainant?
My mother.
14, Your Honor.
Okay.
Judge, 14 at the time of the top.
Can I get that? Yes.
I do remember this case now. And I'm sorry, could I have the trial court certification? All right. And I'm sorry, State, why should I follow your agreement?
Seems like convention of justice with this coming about. Fair prison sentence from the state point of view.
I'm sorry?
It's a fair prison sentence from the state point of view.
So what has he done on probation?
I'm sorry, his probation officer was here a little bit earlier.
Okay.
But according to the court summary, there has been 3 negative UAs. He was in sex offender treatment, but there was some issues there. As far as anything anything else. He was on the so moved caseload, but there's a total credit of $1,163 toward his supervision fees. But other than that, Judge, nothing.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will revoke, find you guilty, sentence you to 8 years in the prison. There's to be no contact with the complainant, no residing in households with minors, no contact with minors, and Chapter 62 registration. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement? Oh, I'm sorry, I need that back. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Could I have his file back, please?
Yes, ma'am.
With the trial court certification. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? Sure. All right, good luck to you.
Thank you.
All right, who else has a contested hearing with witnesses?
Mine is separate contested, but we spoke yesterday
Yes.
about getting.
Who's your client?
His name is Alonzo Taylor, Judge. He hasn't been brought out yet, but I have heard.
Oh,
Scalloway.
what page is Alonzo? Oh,
Page 18, Judge.
18. All right, Norma, if you can set this, it's set for a contested. If you can set it for the third week in January.
I can do the 22nd, Judge.
The 27th?
The 22nd?
All right, 22nd.
Yeah.
All right.
Thank you, Judge.
It's Alonzo, Alonzo Taylor. What, contestant?
No. Reset.
I have a contested one. Judge.
All right, then we'll take your contested matter, but what's the reset?
It's Jonathan Alvarado's client, Caitlin Jeffries.
What page?
She's on page 19, Judge. 4 down.
And this is a probation. We've reset after she was granted probation.
Okay. All right, so what is the status on the evaluation?
So Judge, one of the reasons we got reset was because Ms. Jeffrey was having her parole hearing in between last setting and this setting. She has had her parole hearing and they have decided to continue her on parole, but she is going to be sent to Safe P.
Okay.
One of the questions the court has was she had been referred for further evaluation regarding DDRF, and so the court was going to consider that depending on what happened at that parole hearing. Now, given that she's been ordered for Safe P, as court's aware, that's a super long program, 9 months, I believe it is. I would just ask that she be allowed to start her probation once she gets out of Safe P, that she's already gonna have.
No, I mean, she will be on probation here already. It's just that
Right.
she's gonna have Safe P.
As a condition.
Judge, I'm sorry, this is Caitlin.
Yes.
Okay, so Judge, there was, you just signed an order and amended conditions for her to do DDRF.
Okay.
There was a Tacoma already completed, I believe, and you signed paperwork just recently, maybe days ago, for DDRF, correct?
No, I never signed for DDR.
One second.
And
Ms. Abrams, maybe I have it wrong in my system.
Consider if parole is gonna continue her without any added conditions, if the court was gonna allow her to do outpatient treatment as part of the probation.
All right, if you can do me a favor, just confer with Ms. Abrams and I can take up the plea for Mr. Woodard.
Yes, sir.
Matthew and Sariaga. Court is calling 2025 CR 007924. State versus Matthew and Sariaga. Can I have parties announced for the record for the state?
State?
Defense?
David Andre Woodard for Matthew.
Are you Matthew and Sariaga? Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find the state is in compliance with discovery. Mr. Insiriaga, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it? You're charged with aggravated sexual assault of a child. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge, and he was.
Mr. Insiriaga, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposed to your application. There's to be Chapter 62 compliance, no contact with the complainant, and you're subject to the full range of punishment if you fail to, do y'all mean this to say fail to appear for sentencing?
Yes.
All right, any objection to the court changing the word PSI to sentencing?
No objection from defense, Judge.
And state?
From state.
And you will be subject to the full range of punishment if you fail to appear for sentencing. So your plea will still stand. It's just that your agreement will change to you'll be subject to the full range of punishment instead of 10 years. Do you understand? Sure.
So I would,
No, this is what is going on. The state is opposed to the court granting you probation. You can still apply, but there's not an agreement. The state is not saying they want you to have probation. They're saying they do not want you to have probation. Do you understand? Now, with regards to you're not appearing, I'm going to give you a date to come back for sentencing. If you don't appear on that date, your plea bargain agreement for a cap of 10, which means that the state would only be able to ask for 10 years, will change to the state will be able to ask for life. Do you understand? Did you understand that to be your plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? The waiver of appeal paragraph just tells you whether or not you have a right to appeal certain things. It's this paragraph. Did you review that with your attorney? Did you understand it and sign it? By signing that, you're waiving your right to appeal. The only items that can be appealed are motions that your attorney has filed, and I've ruled on them. Do you understand? Counsel, have there been any such motions?
No, Your Honor.
All right, then to what you're being charged with, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State it offers State's Exhibit 1 and all attachments, Your Honor.
No objections, Judge.
And state, have you spoken with the complainant?
We have, Your Honor.
All right, you may be excused.
Judge.
Did you review this document called waiver and stipulations? Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, today there will be no witnesses live witnesses. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are you requesting a PSI and TAP evaluation?
I am, Judge.
Is there a need for a mental health evaluation?
I believe so, Judge.
All right, I need a PSI, TAP, and mental health evaluation, Ms. Abrams and Ms. Ferguson. What date?
I can do February 12th.
All right, once you sign the reset form, you are excused. I will base my decision upon your application upon any information that's given to me, all right?
Oh. So my brother, he's in the army, was gonna, like, how do I have him, like, get a contact with child support?
Oh, no, what will end up happening is you'll speak to your attorney about that. And whatever information you want me to know, just let your attorney know, and your attorney will let you know if they think it's appropriate for me to know about that or anything else. Just go through your attorney, okay?
And I won't get that.
I'm sorry, what?
Can I ask one more thing?
Sure.
I was trying to see if the permission could go to my child's birth.
Oh, you'll have to speak with your attorney, and your attorney will have to file a motion for that.
Yes, and I asked him, said he was gonna talk to. Said he.
Okay. All right, and is the complainant the mother of this child? Oh, no.
What do you mean?
I said the complainant in this case. All right, then your attorney, once your attorney confers with the state, the court will consider. All right, Ms. Ferguson, I'm sorry, what date?
February 12th.
All right, so we'll be back on February 12th, Mr. Woodard.
Okay, thanks, Judge.
All right, thank you. Once you sign that, you'll be excused.
It was a PSI and TAP.
Yes, and MIC evaluation. All right, Rochelle, are you ready? So what does your client wish to do? All right. Court is calling 2021 CR 11554. We're back on the record, and Richard Cantu. All right, Mr. Cantu, the last time we were here, you pled true to violation of condition number 4. Is that correct?
Yes.
All right. Did you understand by pleading true to violation of condition number 4, the court could grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yeah.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. It is to grant the state's motion, revoke the defendant's community supervision, and sentence him to a term of 4 years in the prison, and then the state would be taking into consideration clause number 2025 PF 43375.
All right, is that your agreement?
It is, Your Honor.
Mr. Cantu, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. All right, the court will find violation of condition number 4 true. The court will follow your agreement, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served, take into consideration 2025 PF 43375. There should be no residing in households with minors, no unsupervised contact with minors, and the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right, good luck to you, sir. Andrew Barham. All right, where are we on discovery?
Judge,
The state has provided discovery, however, I have not been granted the access into the portal. And in fairness, I just substituted into this case in November. And we just had competency restored last week. So I was a little late to the game getting into the discovery portal. I did review the state's file today. The state and I briefly discussed the case, exchanged offers. I've spoken with Mr. Barham about where we're at. We're just not ready to enter into a plea today.
All right, Ms. Ferguson, I need a plea deadline date of the third week in January, please. All right, and I would tell you on these cases, it's always a quick turnaround so that people don't lose competency.
Judge, I'm fine with that.
Okay.
In fact, I think we could probably even do sooner than the 20th, just because I have a jury trial set in Bastrop County that.
Oh, well, if you're able to come back sooner, just ask the coordinator and they'll put it on the docket sooner.
Okay.
All right, thank you. Do you have any questions, sir?
Not this time, Your Honor. Thank you.
All right, thank you. All right, who's next?
Do you have to make this out already?
All right, the competency with Ray Martinez. What is his client's name?
It's contemporary.
All right. Did I say Daniel Jimenez?
David Duenas.
Oh, David Duenas. Oh, it's David Solomon Duenas.
Yes, ma'am.
All right, court is calling 2023 CR 2677 State versus David Solomon Duenas. Could I have parties announced for the record
For
for,
the state of Texas,
and for the defense?
Raymond Martinez.
And are you David Solomon Duenas? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? This is incorrect. Let me see. This was a jury trial.
Yes.
Okay. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same David Solomon Duenas who was placed on community supervision by jury in 2023, placed on community supervision by the court, which followed the recommendation from the jury, and 2023 CR 2677 for the offense of aggravated assault with a deadly weapon on January 23rd, 2024 for a term of 5 years? Is that you? State?
Violation condition number 1, on or about the 9th day of October 2025 in Bexar County, Texas, the defendant, David Solomon Duenas, committed the offense of assault on violation condition number 1.
How do you plead to that? True or not true?
Violation condition number 2, on about the 12th day of September 2025 in Bexar County, Texas, the defendant, David Solomon Duenas, did then and there illegally use a controlled substance, namely cocaine, in violation of condition number 2.
How do you plead to that? True or not true? All right, state, call your witnesses.
This time, Your Honor, state will call Terrence Williams.
All right.
And Judge, before they call the number 1, before they try to prove that one up, I wanted the court to be aware that we would prefer to have our jury trial on the number 1 violation. And it's been indicted already. We're ready to go on it as soon as the court could, but because of the different standard of proof, I think in all fairness, my client should be afforded his right to a jury trial on that.
All right, we're going to proceed. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record. All right, state, you may proceed.
Thank you, Mr. Williams.
Good afternoon, sir.
Could you please introduce yourself to the court?
My name is Terrence Williams. I'm a CSO for Perrytown
How long have you been a CSO with the Bexar County, Bexar County?
since 2025.
In your employment with Bexar County probation, have you come into contact with someone whom you now know to be David Solomon Duenas?
Yes, sir.
You see that person in the courtroom today?
Yes, sir.
Could you identify him, please, by an article of clothing that he's wearing?
Black vest, black long sleeves and glasses.
Mr. Williams, can you please tell the court, when was your first interaction with Mr. Duenas?
September of 2025.
And at that meeting, did you go over anything with Mr. Duenas?
Yes, went over acting a series of
Yes,
questions.
been non-responsive, Judge. You just asked him, did he go over things with him? The answer is yes or no.
Yes.
What things did you go over with Mr. Duenas on that day when you first met him?
So some things I went over were his employment, place of address, and
had he had any contact with law enforcement, the police, or any arrests.
And what was the purpose of that last question for having any contact with law enforcement or arrests?
The purpose for that question was to determine if he was violating any conditions under his probation.
And what condition of probation would that be?
Violations of committing a new offense.
No further questions this time, I'll pass the witness.
No questions, Judge.
All right, thank you. Is this witness excused or subject for recall?
Excused by the state.
Judge, I'm not really sure what role he plays in the overall scheme of my client's probation. I don't know if he's a regular probation officer or just, it was just that particular day.
Mhm.
If he's a regular probation officer, I'd like him to stick with that.
I understand this.
Okay.
All right, so if you could remain. Thank you so much, and thank you for your patience. All right, call your next witness.
Your Honor, this time state calls Miss Karina Luvano. And if I may just check.
Sure.
Thank you.
All right, are you all planning to address violation of condition number 2 or no?
No, Your Honor. Just number 1.
All right. All right, if you'll come forward, please. All right, just keep your voice up so defense counsel can hear, I can hear, and the state can hear, all right? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Everyone, please whisper. If you'll state your name for the record.
Lovano.
All right, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Luvano. Do you know someone by the name of David Solomon Duenas?
Yes.
How do you know him?
My ex-fiance.
How long have you known?
Around 5 years.
How would you describe the nature of your relationship with Mr. Duenas?
Can you ask that again? Can you ask that again, please?
How would you describe the nature of your relationship with Mr. Duenas?
I don't understand. Yes. Mhm.
Have things always been good between you two?
For the most part, yes.
Have things ever gotten physical between you two?
Yeah.
Was there an incident that took place on October the 9th of 2025 where things got physical between?
Objection, leading the witness, Judge.
That'll be sustained.
Hold on, I'll answer that question, and that's your question. But has there recently been an incident that took place between you and Mr. Duenas?
Yeah.
Do you recall when that was?
Not the specific date, no. I'm going to ask you a question.
No, not while you're under oath.
Okay.
No. So what ends up happening at this stage, they just ask you questions. The state will be able to ask you questions. Just listen to his question, answer his questions. And then if the defense attorney wants to ask you a question, just listen to their question and answer their question. If for any reason you don't understand the question that's being asked, just let them know you don't understand it, okay? Because sometimes attorneys can use a lot of legalese. All right. So if it's something you don't understand, just let either party know you don't understand it, okay?
Can I jump in on that question, Judge, just to clarify for the court?
I
Yeah.
have a good question.
No, yes, proceed.
Thank you. Mr. Bonner, do you want to be here right now?
I do not.
You're here because you're under subpoena?
Yes, only because I'm under subpoena.
Do you recall meeting with the police recently?
Yes.
Do you recall making a statement to the police recently?
Yes.
We're looking at a copy of the report to refresh your memory as far as when that interaction with the police took place.
Yes.
Judge, I'm going to object to her refreshing her memory with something that's other than her statement. The police report is the officer's version of what he did at the scene, not what she said. She needs to look at her own witness under the Gaskin rule. She's got to see her own statement that she wrote or video statement. Refreshing her memory with somebody else's is inappropriate.
No, that's not the law. The objection will be overruled. Yes.
Ms. Levon, if you could look at this page, please. Look at it to yourself. Do not read aloud from it. And look back at me once you feel like your memory has been refreshed. remember, I've been refreshing so long. Do you remember when this incident just about earlier about things being physical between you and Mr. Duenas took place?
You're actually leading the witness, Judge.
Overruled.
October 9th, 2025.
Can you please describe to the court how things began on that day?
Okay.
Can you please describe to the court how your interaction with Mr. Duenas began on that day?
We had a disagreement.
What was the disagreement about?
Me asking for the apartment key, his copy
Of your apartment?
of his apartment.
Of his apartment. Where do you live?
No longer in that apartment.
Okay. You described wanting a key for that apartment?
Yes.
Why did you want that key?
He no longer lived there or paid bills, so I didn't want him to have access to the apartment.
Okay. At that time, who lived in the apartment?
Myself and my 3 children.
Okay. Do you and Mr. Duenas share any children in common?
Yes, we share 1 child.
Okay. How old is that child?
She's 3.
What's her name?
Ariela Dueñas.
Okay. Does he have like education rights with that child? With that child?
No set visitation rights, no.
Like no formal?
No formal,
Is there
right?
like an informal agreement between you two?
Yes.
Okay, and what is that agreement?
He would just pick her up when he had time or was available.
Is that what he was trying to do on this day?
Yes,
He was trying to pick up the child that you have in common?
yes.
Okay, and happened when he requested that.
We agreed for him to pick her up.
Pick her up at your apartment?
Yes.
Okay, so did you go to the apartment?
Yeah.
What happened when he got to the apartment?
He went upstairs for my daughter. She was sleeping.
There's in the apartment?
Yes.
Okay, and what happened after that?
After he went upstairs for my daughter, he came downstairs. I asked him for the apartment keys.
What happened when you asked for the apartment key?
He told me that I didn't need it back.
How did he react? I guess what was his mannerism at that time?
Calm.
What happened after that?
He made a comment that upset me. So I guess we got into a disagreement.
Okay, so would that be like an argument?
Yes, an
Verbal
argument, yes.
What happened after this verbal argument took place?
I don't remember like the specific sequence of it.
That's fine, to the best of your knowledge. Tell the court what happened after this verbal argument took place.
He I guess charged at me.
Okay, and where were you in the apartment he charged at you?
It's like an open space, so he was closer to the it's all like the same space, but he was closer to the front door and I was in the dining room.
Okay, so it was at that point that he charged at you while you were in the dining room?
Oh, I forgot that he set my daughter down.
He sat your daughter? Okay.
Set her down on
Set
the
her down.
sofa, she was sleeping.
Okay, and so it was after that he charged at you while you were in the dining room?
Objection, leading the witness, Judge.
All right, that'll be sustained.
Was it after that when he charged at you?
Yes.
And what happened when he charged at you?
I don't really remember what arm grabbed my neck or how I was positioned. I don't remember if I gave him my back. Or if it was head front, but his arm or his hand was around my neck.
His hand was around your neck?
Yes,
Do you recall if you were able to breathe at that time?
I was able to breathe, yes.
Do you recall how long his hand was around your neck.
No,
But you're testifying to the judge right now that he put his hand on your neck
yes,
right after he charged at you?
yes.
Okay, and what happened after that?
After that. I want to say that we had another verbal argument.
That's what I'm gonna take one step back. I forgot to answer your question. How did your neck feel when he put his hand around your neck?
I don't remember how.
That's fine. Okay, so then you had another disagreement. Is that what you just said?
Yes.
Like another argument?
Not necessarily argument, but well, I guess yes, we were shouting at each other.
We're shouting at each other. What happens after you guys are shouting at each other?
I don't remember. I don't remember if he was leaving at that point or if that's when he had charged me again.
Okay, so you don't remember specifically the sequence, but was there a second time when he charged at you?
Yes.
What happened during that second time that he charged at?
He went, I don't remember if I cowered. I don't remember if I gave him my back or if he charged me like head straight, but he went for my neck again.
And was he able to put his hands around your neck this second time?
Yes.
Were you able to breathe?
Yes.
Do you remember how long he had his hands around your neck the second time?
No.
How did your neck feel that second time after he put his hands around your neck?
Honestly, I didn't have any neck pain until the following day.
Oh, okay. Right, so what happened after this second time that he charged that you and put his hands around your neck?
We got into, well, I want to say at that time, I was telling him that I was going to call the police.
And what did he do in response to you saying that you were gonna call the police?
Broke my phone.
He broke your phone. Okay, and what did you do after he broke your phone?
Well, I don't remember. I know he mentioned something about calling.
Objection, not responsive, Judge. The question was, what did she do?
Overrule.
You may continue to answer.
The disagreement, I know was something, he had mentioned something about like calling whoever I wanted, calling the police, calling my brothers, calling a boyfriend. And that's when he broke my phone.
Oh, so that's when you broke phone. What happened after that?
He choked me again.
So this would be the third time that he choked you?
I don't remember.
Well, you testified earlier that there were two prior times when he had choked you, right? So this is the next time. That's just be the third time after the first two. Is that correct?
The third, yes.
Okay, so what happened this third time when he choked?
This third time. I think that's the one where he ordered me into the kitchen.
Okay, so he cornered you in the kitchen. What happened after he cornered you in the kitchen?
And that time I couldn't breathe.
That time he choked you, you couldn't breathe?
Yes.
So he had his hands, did he have his hands around your neck?
Yes.
Do you remember how long he had his hands around your neck?
I don't remember if it was both hands or how long.
All right, any other questions? Or do you pass the witness? Defense?
Ms. Lavalla, you started with telling the court you were not really interested in being here to testify today. Is that right?
Yes.
And there's multiple reasons for that, correct? One of the reasons is you don't remember all the things you said at the police that day. Is that fair?
Yes.
There's another reason because when the two of you get into arguments, you both get physical with each other sometimes. And you're concerned about being under oath in front of a judge, admitting to striking or assaulting my client. Isn't that true?
Objection, Your Honor, to television.
Overruled.
Well, let's go back. Let's go back to the beginning. How long did you and David live together?
I want to say 4.5 years.
Okay. And in those 4.5 years, there were previous arguments that turned physical, correct?
Yes.
And in some of those instances, you assaulted David, correct?
Yes.
And in some of those instances, you used weapons and or whatever you could find to put your hands on to assault him, correct?
What are like?
Well, for example, there was an occasion where you hit him with a frying pan or a pan of some kind in the kitchen and split his head open, correct?
In self-defense, yeah.
So you and he have had this kind of a relationship up until you separated,
Yes.
right? And so, to be honest, he was coming over there to pick up your daughter, y'all's daughter, and take her for the evening, correct?
Yes.
And when he found that she was asleep, he changed his mind and said, I'm gonna let her sleep. And he decided he was gonna leave her there, right? Do you remember that? Okay. Isn't it true you told him, no, I already have plans, I was gonna go out, and you need to take her, I can't leave her here by herself? You don't remember that conversation?
No, I never said that I was gonna leave her, so.
Well, not that you're gonna leave her by herself, but she was too young to be in the house with your older children. Correct?
No,
That wasn't a point of contention.
I did mention that I had plans that night, yes.
So the person who got upset or the problem that occurred was when you got upset to him choosing to leave the child and not take her because she was already asleep. Object this argument.
Overruled.
But that's why I'm not having it started, as you're saying.
In essence, you were the first one to get upset because of his taking that position at that point.
I didn't get upset, no.
Okay. Now, when David eventually came down and had the baby in his hands, isn't that when y'all were still arguing? He never, well, you say he put the baby down, so at some point he must have had her.
Right, yes. we
Okay.
had.
And isn't it true that you became physical with him while he was still holding the baby in his hands?
That's not correct.
Okay. But at that point, you were already arguing.
It wasn't really arguing, we were just exchanging words.
Okay. Well, then what would be the need for him to put the child down? Isn't it because you were approaching him in an aggressive fashion? Okay. So he put her down so that he could commence the assault on you. Is that the position you're taking?
Right.
Okay. So, Ms. Lubano, what statement or information did you review before your testimony here today?
Like if I read my statement.
Right. Do you have a handwritten statement that you wrote that you might have read before you came down here today?
No.
Okay. Did you have a video statement that you watched?
No.
So you don't remember, you didn't refresh your memory before you came to testify about what you told the police? So is it your testimony that he never restrained you, put his hands on you or anything like that in response to what you did first?
No.
You didn't do anything.
Right.
He just unilaterally decided, I don't like the way this conversation is going, I'm just gonna choke you. Is that what you're telling the court?
I requested the key for the apartment and that's what upset him, yes.
Now, did you request the key or were you being demanding or physically aggressive with him?
Yes, that's your objection.
Overruled.
Can you ask that again, please?
Well, the way you're saying it to the court right now, I asked for the key back, makes it sound like it was a very simple, calm request.
Right.
Is that exactly the way it happened or was it a different demeanor?
Yes, I asked for it calmly. He said that he doesn't stop by unwanted or like without letting me know first, and then he asked me why do I need it. I did become upset, told him that I don't need to explain myself.
But to be clear, Ms. Lubano, this was his apartment, correct?
Yes.
In other words, the lease was in his name.
Yeah.
And so he was ultimately responsible for the condition of the apartment.
Right.
and to return it in good order.
Yes.
So him having the key, you weren't really in a position to demand that he give it back to you, correct?
Sustained.
But, and it got worse from there. Is that fair to say?
Yes.
Okay, now, you guys weren't by yourself at that time, right?
Right.
Who was there?
My 11-year-old daughter.
Okay, and your 11-year-old daughter has seen you and David fight before, correct?
Not physically, no.
Okay. She's heard the arguments.
Yes.
And on this particular occasion, she did witness, correct?
Yes.
Okay, so if she would have been made available to law enforcement or to the state, they could get an eyewitness's version of what took place.
Right.
Who the aggressor was, who did what.
Right.
Okay, but that hasn't been done. Or I'll ask another question.
Sustained.
Have you advised the state that you had an eyewitness who could corroborate your version of the events?
No.
Do they even know that?
It,
That
it's
she,
in the statement that she was there, yes.
okay. But when the various times that you come down here to talk to the state, you guys have not shared that information with her.
Or, I'm sorry.
Have you shared with the state that your daughter witnessed the events?
Object to ask and answer, Judge.
That'll be overruled. You can answer it.
Could you ask that again?
Have you let the state know that she was there and saw what happened?
I believe so. Yes.
Now, Ms. Levano, this isn't the first time you've made accusations against David, is that correct?
Overruled.
You've accused him of physically assaulting you in the past, correct?
Not to the police, no.
Didn't we have a jury trial on an issue where you accused him of assaulting you, where you were a victim in the case? Sure?
Mhm.
Wasn't he found not guilty on one of the counts of his trial that we had, that he's currently on probation for? No?
No.
May I consult my client real briefly,
Sure.
Judge? Okay, Judge, I'll move on.
Right, so were you able to find the answer to that last question? That it was or was not her?
I'm gonna move it on to something else.
Okay, so it wasn't her?
She was not the complainant in the case. Sometimes
Okay, yeah, no.
people have more than one ex.
Oh, no, I understand. I just wanted to make sure there.
Sometimes many more.
Yes.
So let's talk about the issue with the phone, Ms. Levano. He actually bought that phone, correct?
No.
He didn't claim that he owned it? That wasn't part of the argument that, he could take it because it was his and y'all fought over the phone for that reason? Okay. So, Ms. Levano, let's go back to where we started this question. We never got to the reason why you didn't want to testify in court today. Are you concerned that there's things that you told the police on the dating question that are not true?
No.
Are you concerned that he's going to be subject to going to prison over false statements you made to the police? Or misleading statements to the police? Is that part of the reason why you didn't want to testify, is that you didn't want to be put in a position of having to say things today that may or may not match what you've said in the past?
Sustained.
I think it's cross-examination, Judge, but I'll move on.
No, I mean, he's saying it's been asked and answered. So that's the objection I'm sustaining, but you can ask more questions.
On the whole, Mr. Bono, isn't it fair to describe your relationship as one where both of you have been in the wrong in terms of how you treated the other person on occasions?
Yes.
Up to and including being physical with the other person. And in a similar instance like that is what happened in October of this year.
Yeah.
And so you don't want him to be punished for maybe what both of you might have been in the wrong of doing that day. Is that fair?
Overruled.
Yes.
you started out by telling the state that for the most part, your relationship with David has been okay.
Yes.
You still stand by that?
Yes.
You believe that if he were to continue on probation, that you and he could manage how your child was shared between the two of you without having to maybe be in the same place at the same time?
Yes.
That's what the relevance from.
That'll be overruled.
Has there been a protective order issued in this case? Is that, and he agreed to that, is that right?
I'm not sure.
Okay, well, okay. But is it fair to say that there's blame to go spread around between yourself and him for what happened in October?
Sustained.
I'll ask you another question, Mr. Water. You said that on a couple of occasions he grabbed you. Isn't it fair to say that he's grabbing you as you're being physically trying to strike him? Objection, absolutely.
Overruled.
Defending them both.
Like he's grabbing you and you are swinging at him. That's my question.
No.
So you never attempted to strike him in any form or fashion. Okay, and you were totally defenseless the entire time and did nothing in terms of participating in a fight. I'll pass the witness, Judge.
All right, thank you. Okay. Sure.
Do you see the person in the corner that did this to you?
Yes.
Could you please point him out and describe him by an article of clothing that is wearing?
Brown.
Do you recall meeting with the police after this incident took place?
Yes.
Do you recall having photographs taken of you back then?
Yes.
That's what she.
Yes.
I'm handing you what has been pretty much exhibit 1, 2, and 3 for identification purposes. I'm going to hand these to you. Can you please hold them and tell me what you see in this one that's marked as exhibit number 1?
Picture of myself.
Good. Let's move on to number 2. What do you see in this picture, Ms. Obama?
Marks on my neck.
Let's move on to number 3. What is in that picture?
Scratch.
Okay. Ms. Obama, these pictures that you just saw, they were made the same day as this incident took place? Are they a fair and accurate representation of how you appeared on this day?
Yeah.
With your knowledge, have these photographs in any way been altered? This time, your state officer evidence takes exhibits 1, 2, and 3, and I'll return to defense for review.
No objection to number 1, Judge, and I'd like to take on board our number 2 and 3.
All right. State's exhibit number 1 is admitted.
Now, Mr. Obama, in regards to picture number 2, why does that look like that? Do you know, in terms of the darkness of the picture?
The lights were turned off.
Okay, is that the same case in number 3?
Yes.
Okay, so this is not. This is a special form of photography or science that allows them to do this kind of thing. Is that right? If you know, for knowledge, well, that's my whole point, Jim.
Do you
She doesn't
know? Let me see state's exhibits 2 and 3, please.
I would suggest she's not able to sponsor these because she doesn't know what these are showing and what they mean. She's
All
never
right.
seen them before.
The defense's objection to states 2 and 3 will be sustained. State's exhibit number 1 will be admitted. Any other questions for this witness, state? Any other questions?
Yes, if I may ask for more questions about this picture. You testified earlier, Mr. Vano, that these pictures questioned the day of the incident, correct?
Yeah.
They were with police. Do you recall them having to take special pictures of the areas that are depicted?
Objection, leading with this judge.
Sustained.
Do you recall them having to take pictures of the areas that are depicted in these pictures?
Yeah.
Do you recall if the lights were on and off at these particular times?
The lights were off.
Okay. Can you tell in these pictures that this is you and this is me?
Yes, the man in that.
Absolutely.
All right, defense's objection to state's exhibits 2 and 3 will be sustained. Any other questions for this witness?
None from the state. No change.
All right, you may be excused. Thank you. You can, well, no, just have a seat in the courtroom, please. Any other witnesses?
None from the state.
Defense, any witnesses?
Richard Williams, Judge.
All right, Mr. Duenas. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna need to speak up so I can hear and the court reporter can hear. You can lower your hand, state your name for the record. All right, defense, you may proceed.
Mr. Duenas, do you recall the incident in October with Ms. Levana who just left? And the two, do you agree with her that the two of you were together in a living together relationship for 4 years or more? And you have a child together? Okay. In what was your child's age at the time? Yeah, more or less, yeah. And how long have the two of you been living apart? Okay. So you knew that she already was in a new relationship, correct?
Sustained.
Did you know whether or not she was in a new relationship? And had you ever informed her whether or not you had proceeded to a new relationship? Okay. So was there any leftover issues between the two of you, or were you at this point separate and apart permanently? What do you mean by she had issues? You need to speak up.
My daughter. She.
That's speculation, Ron.
All right, that'll be sustained. And I'm gonna need you to speak up because I can barely hear you. I know the court reporter is struggling. All right, the objection to speculation as to the thoughts and feelings of the complainant, that will be sustained.
Okay, so what was the reasoning for you to be there that day?
She asked me that, called me while I was at work if I could pick up the baby. She had plans.
Okay, and did you agree to do that?
Yes, I was going to dinner with my partner.
Okay, and were you working that day? And so what time did you make plans to be there to pick her up? Okay, and so did you get to her apartment around roughly that hour? Okay, and what was her demeanor like or her behavior at the time when you first encountered her that night?
She was fine.
Okay, so everything is fine. Okay, and at some point, did that change? And what caused that to happen? A little bit louder, Dave, please.
The baby was leaving that couldn't wake her up. She was tired and put her out. Then come back to her mom. I was off the next day.
How did she respond to that?
She said she already made plans and I was already there for me to take her. And I told her that she really wanted to go at her mom when she was tired. I was very late. Since I was the girl in the morning.
So you didn't leave her upstairs to sleep, you actually picked her up and we're gonna take her.
Yes.
What was your concern? Why did you not want to do that?
I've been home in 8 months, so she's not that comfortable with me again, so.
Objective speculation, Your Honor.
Overruled.
You can finish your answer.
She not that comfortable, she has, but she cries and so I didn't want that to happen.
Okay, and did you express that to her?
Yes, I told her that she replied that she needs to get used to deciding to take her.
Okay. And at some point, did the tone of voice between you or her change? Okay, and then what proceeded to happen next?
And that I, whatever I want, and
Objective to hearsay. Your Honor.
Overruled.
So she's cursing at you, she's upset with you, and what happens next?
she told me about money, she wanted money
and how much spending is with my son, like even her money to their apartment and help them out.
Okay. So even though the two of you had separated, she's still living in an apartment that you're financially obligated to pay, is that right?
Objection, leading, Your Honor.
Overruled.
But so all these things start coming out from her complaints, suggestions, comments, whatever you want to call them, after you told her you were gonna leave the baby.
Objection, leading and relevant.
Overruled.
You tell the judge, David, tell me what happens after you tell her that you don't want to take her in that condition she was in at the time.
Well, not giving what time to do, help me out. That's it. This part of how she let me, so that made her mad. We just continued to argue back and forth on the kids. She was in a car with them.
Okay, so what does she do next?
Home.
Okay, she grabbed your phone? Okay. So why was she grabbing your phone if you know?
Objective speculation, Your Honor.
Overruled.
Has she ever taken that tactic with you in the past when you guys have argued? Okay. Now, I asked her the question about whether or not she'd ever been physical with you. What is your answer to that question? Okay. And so when I say that, describe for the judge the kinds of actions she's taken against you in the past.
And on my head in front of the children and the fun of talking to you, I had nothing.
Now you say glass pan, describe it for the court.
That's the,
Okay, so it's like a dish that you would store food that's cooked in? Okay. Did it break? And what was the injury that it caused to you? And did you file a police report as a result of that? Okay. Is this the first time that she'd gotten to that extreme with you? So that was the last day that the two of you all were together? Okay. Now, you heard the way she described the way that you were acting that day, correct? She characterized it as you charging at her. Did you do that?
We're fighting over the phones. We discussed this.
So it was strictly the two of you. Were you fighting over your phone or fighting over hers, or both?
She had mine. Just trying to.
Okay. So at any point other than trying to get your phone back or taking hers, did you put your hands on her? Okay. She talks about being cornered in the kitchen. Did the tussle or the back and forth over the phones move around the apartment?
I'm not sure for the phone. She would walk back and then try to get my phone. But we still go back and forth.
Okay. You heard me ask her about her 11-year-old. Where was she at this time?
Watching.
Well, when you say she's watching, where was she? So in the same room y'all were in. Would you say she was there the whole time? Are you on good terms with her?
Objective to relevance, Your Honor.
Sustained.
To your knowledge, well, yeah, something else. Why did you leave after this all kind of, I guess, calmed down?
She showed me my phone back so I little kid, and I broke it over. The daughter started crying and hugged her angry, and I grabbed my phone and left.
Now, the phone that you broke, was that your phone, or, I mean, who owned the phone? Okay, so she was using it, but okay, you understand that probably wasn't the best move. Okay. But did you throw it at her or strike her with it or anything like that?
My phone got left it here.
Okay. Now, since she's gotten this protective order, has she reached out to try to communicate with you?
Object Mr. Relevance, Your Honor.
Overruled.
Since the protective, well, let's go back. Did you agree to a protective order with her? And when did that happen? Okay, so sometime after October. And you agreed to it in the sense that you signed off on, is that right? Now, even though you got that order, has she still tried to communicate to you directly or through another person?
Object Mr. Relevance.
Overruled.
Has she tried to get messages to you or to communicate with you, even though the protective order is in place? Did she contact your family? I'll pass away, Judge.
State.
Mr. Duenas, you have animosity toward Ms. Luano, correct?
I don't know what that word means.
I can't hear you. I'm sorry. Can you turn towards me?
I don't know what that word means.
You don't like her really anymore, do you?
I still love her. Mother of my daughter.
I can't hear you again. Could you?
I still love her. She's a mother of my daughter.
Well, you have anger towards her, right? You don't have any anger towards her at all. So you just left because you just wanted to leave, right? Because it was a happy situation for you to leave, right? You were happy in doing so. You weren't angry at all at her because of what you're saying she did to you, right?
From that day? From what day?
Okay, well, let me help you out then. You were testifying earlier with Ms. Martinez asking you questions that you don't live with her anymore, right?
Yes.
If you had moved out, right?
Yes, sir.
You were angry in doing so, right?
I was just sad that our family is broken, so I left. There's nothing I can do.
There was nothing at all you could do to try and make things better, right?
No,
You certainly couldn't act better on your end towards her, right?
because I moved, I made my decision to get away from her.
Okay. So because of that, and you having to now live somewhere else, this is an inconvenience for you then, right?
No,
Okay. You have to make arrangements with her whenever you want to see the child that you have in common then, right? No, you don't. So you just go whenever you want to over there?
you said yes or no, and I don't argue.
Right, exactly. Those are arrangements that you're making with her to see the child, right?
Oh, yes.
Okay. So on this day, you had made an arrangement to go and see your child then, right?
She made an arrangement with me.
So you never reached out to her first?
She reached out to me.
She reached out to you, okay, so, but you still said, okay, I'm gonna go and see my daughter then, right?
Yes,
You went over there after work, as you testified earlier, right?
yes,
Okay, and when you got there, you went to go and see your daughter, right, who was upstairs sleeping?
yes,
Okay. And after that, you brought her downstairs, right?
yes,
Was she still asleep at that time?
yes.
All right. And then there was an argument that took place between you and Miss Lavanu, right, about a key to the apartment?
More things too, but yes.
Okay, well, that was one of the things you argued about, right?
Yes,
And you didn't want to give it to her because it's your apartment, right?
yes,
Because in your opinion, she doesn't have a right to have a key to the apartment that she lives in with her children, right?
she was moving out.
Well, at the time it wasn't though, right?
No,
The time it was active,
the lease was already expired and
it was expired, so you were allowing her to live there after at least that expires. Is that what you're saying?
yes, because she was moving out, she said.
Okay, so the apartment complex was aware that there's someone living in this apartment that's not on the lease.
Yes,
Okay, that's what you're saying. All right, so you get there that day and you guys have this argument about that makes you angry, right?
no,
You didn't get angry about anything. Okay, so you're calm, having a conversation with her the entire time.
about the key, I wasn't upset,
Okay, but okay, other things then upset you then, right?
but
Yeah, you got upset, so you went at her, right?
no,
You never went at her? You never put your hands on her neck? Never choked her at all? Never lifted her off the ground with your arms around her and on her neck?
not that strong to lift her off the ground, no, I would never.
Okay, so you never did that either. That's not true.
No, it's not true.
Okay, but so the only thing you did is grab her phone and smash it then, right?
I just grab my phone.
After she grabbed yours. So you grabbed yours in retaliation and you smashed it because you felt like it's your phone and you own it and you can do whatever you want, right?
Yes.
Okay. So, and this was done in front of her children there, right?
Yes.
You felt like that was appropriate behavior to act like that in front of two children?
No.
You still did it anyway though, right?
Yeah.
Okay. One of them being yours, right? Okay, so it didn't matter to you at that point how that might affect them, right? You were just too angry to care about that. You were, okay, so you just snapped the phone in a calm, nice manner, right?
Father's very trying to get out.
Wanted to get out, so you did that. You just got out there and you left your child there, right?
Yes.
At that point, you didn't care, you just wanted to get out. Okay. And you're obviously aware that you're on probation for a case that you had gone to jury trial on, right?
Yes.
And is it important to you to keep up with the terms of those probation?
Yes.
Because you want to be on probation.
Yes.
You want to do well on probation.
Yes.
And you felt like this was the appropriate way to show that you're doing well on probation?
That's why I wanted to leave. That date, that's why I was trying to leave.
You were trying to leave, even despite all this stuff, you were wanting to leave because of your probation.
Because she kept saying she was gonna call the police.
Okay. Did you ever call the police that day to tell them your version of what happened?
No, because I didn't hurt her, so I wasn't aware of anything. I just thought it was, I didn't hurt her, she didn't hurt me, I just thought we would just talk to each other, and just blow it over, and she'd apologize, because she always does, she'll apologize. And we try to co-parent, that's all I thought was gonna happen, I didn't hurt her, I didn't do anything to her, so I didn't think of everything was gonna happen.
All right, any other questions?
From the state.
Any follow-up questions?
Not on the allegations on number one, Judge. No.
All right. Any other witnesses from either side?
None from the state.
Judge, I would have questions for probation, but not as to the truth or not untruth of the allegations of number one, just depending on if that's necessary. But I was simply going to ask,
No, what questions you
well,
have?
just like how he's doing on probation, whether he's all the things he's supposed to be doing, things like that. But
All right.
I don't remember his name, Judge.
That's okay.
Yes.
Yes.
Williams?
All right, you're still on, defense tells me they have some questions. They just want to know how Mr. Joynes was doing on probation other than with this allegation.
Your Honor, he was doing fine, was showing up on time for his virtual visits. Unfortunately, he tested positive for cocaine and cardiac effects. Other than that, he showed up on time.
Well, but he's done more than that, to be fair, right? He's completed classes, correct? Matter of fact, you have a listing of all the things that he's completed. Tell the judge all the things he's completed on probation.
So he's completed matters of intervention, GPS. He provided a DNA sample in his parenting class.
What about community service?
Yes, he's completed community service.
Well, how's he done on his payments?
So he made payments. He does have a balance of $3,712.
Okay, but that includes probation fees that are due in the future, correct?
Correct.
How much is he actually paid towards probation?
So he's actually paid $244.
Okay. Now, isn't it true that you advised him that because of all the things he's completed, and if he got current with his probation fees, that he might be eligible for early termination?
Reject this time, Ms. Ryan.
Overruled.
You didn't have that conversation with him? Okay. Who did he have before you? Or did he have somebody before he's been?
Yes.
Okay, so you've only been on the case just a couple
2
months. Okay. That's what it should.
I have no
All right.
questions, Your Honor.
Thank you so much. All right. With regards to violation of condition number 2, the court is finding it not true. The court will note for the record that the probation officer did state that Mr. Duenas, I believe, tested positive, but the court is not considering that because I know that the defense was bringing the witness strictly for the purposes of how he was doing on probation and with regards to whether or not he tested positive for cocaine, lab reports would need to be presented and the person, whoever is responsible for doing the testing, would need to come in and testify. So that'll be found not true. With regards to violation of condition number 1, the court is finding violation of condition number 1 true. Is there a request from the state?
Yes, Your Honor, that request is to revoke the defendant's probation and sentence him to 2 years in prison.
All right, defense.
Well, clearly, Judge, we're not in agreement with that. And now that you've heard the testimony in the case, you can see why we're anxious to take this case before a jury and get a determination after a full and complete trial of all of the issues with all of the witnesses and other evidence that's relevant and admissible in court. Due to his performance on probation, Judge, and his obligation in terms of support, his voluntary acquiescence to the protective order, we'd ask the court to employ one of the many sanctions that the court has available and to keep him on his probation. If nothing else, at least until we resolve that new charge. The state's gonna have another shot at him. In that case, they can ask for a full range of punishment and they won't be limited to the 2 years that the court has in this situation. I think Ms. Levana was honest when she said that it's a two-way street. And she was being very kind to herself about that. When you smash a pot over somebody's head and then embed glass into their shoulder, that suggests you the type of person that she really is. And why she admittedly was reluctant to come and testify in court because there's things that she's done and contributed to this situation happening in October that she's not proud of either. I think they both are embarrassed that all this had to come to light in public, and they both could have done better and handled the situation than and so, Judge, in light of everything, rest in the court not to revoke his probation and to consider other alternatives.
All right, and counsel, have you completed the trial court certification?
I have not, Judge. I've been kind of busy last few
Oh,
months.
if y'all will complete that for me, please. All right. The court is going to grant the state's motion to revoke. The court will sentence you to 2 years in the prison, giving credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Danessa Duenas, Christian Rodriguez, and Charles Waterson. And that's from the previous conditions that were given when you were placed on community supervision by the jury. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? You do have a right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you're in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition, okay? All right, good luck to you, sir. Hello, Mr. Sullivan. All right. You're right. All right. All right, the court is calling 2018 CR 8528 State versus Eddie Leroy Sullivan III. Can I have parties announced?
Lauren Espinoza for the state.
And Jonathan Alvarado for the defense.
And are you Mr. Sullivan? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Eddie Leroy Sullivan III who was placed on deferred adjudication in 2018 CR 8528 for the offense of obstruction or retaliation on June 11, 2019 for a period of 5 years? Is that you? All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant Eddie Leroy Sullivan III did then and there fail to report to the supervision officer as directed for the months of September and October 2024 in violation of condition number 5.
How do you plead to that? True or not true?
State will waive the remaining violated conditional.
Any objections?
No objections.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. And counsel, it's my understanding that your client was found competent, correct?
Yes, Judge, and I was reappointed onto the case after that evaluation was ordered, but I had reviewed the order and was found competent.
All right, is there a proposed agreement?
There is, Your Honor, the proposed agreement is to grant Steve Wilson sentence Mr. Sullivan to 2 years in detention.
And there is also, Judge, a misdemeanor case he is going to plea on that case.
Are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, why were you not successful on probation?
My grandparents, paid for the safety. Still found it, that it means I would go down to.
All right, and that violation of condition number 5, that is in count 1 as well as count 2, correct? All right, so the court will follow your agreement. And are you waiving your right to appeal? All right, the court will follow your agreement, find you guilty, and revoke in counts 1 and counts 2, sentence you to 2 years in counts 1 and count 2. Give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's to be no contact with Michael Ebrom, EBROM, and M. Bennett. Counts 1 and counts 2 are to run concurrently. And our request the therapeutic community, it doesn't increase the time that you've been in custody, but it will help with any addictions you may have. Is there anything else with regards to sentencing?
Nothing else.
Counsel. You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So, Mr. Sullivan, when you're released from custody, if for some reason you cannot find a place that can help you maintain your sobriety, if I'm still here, you come back here and I'll make sure that I pick up the phone to call someone who can help you with transitional housing. But you gotta want it. All right? All right, good luck to you, sir. All right, the court is calling 2025 CR 011985, State versus Abdul Ghaffar Khan Kunifa Gul.
Aurora, وای تاسو نوم مو اوس غږ کوي چې 15 کال CR 00119 عبدالغفور خان.
All right, could I have parties announced for the record for the state?
اوس یو نفر راځي ریکارډ کوي د سټیټ ته طرف نه.
Lord Espinoza for the state.
For the defense.
David Rodriguez for the defendant.
All right, and he just stated James Rodriguez for the defendant. Everybody's going to have to speak up so she can hear. I'm sorry, David Rodriguez for the defendant. I need everyone to keep their voice up.
دا وکیل چې دی دا خو ته پیژنې دا ډیوډ دا ستا وکیل دی ښه مدافع وکیل.
All right, and we have an interpreter by Zoom. To the interpreter, could you raise your hand for the court, your right hand?
Yes, Judge, I do.
Do you solemnly swear and affirm you will faithfully translate from English into Mr. Gould's language and from Mr. Gould's language into English?
Yes, Judge, I do.
All right, you can lower your hand. And can you tell the court what is Mr. Gould's language?
It is Pashto.
All right, thank you.
Thank you, Judge.
All right, Mr. Gould, all of the documents that I'm going to review with you are in English. Were those documents explained to you in your language?
عبدل وروره وای د قاضي وایي چې زه دا ټول اسنادونه چې دی یو ځل بیا د مرور د پاره په انګلیسي درته وایم او زه به ته ترجمه کوم وروره صحیح شو؟
صحیح شو.
Okay.
What's the answer? I need a yes or no.
وایي چې ماته جواب راکړه چې هو راته ویل شوی دی او نه راته نه دی ویل شوی.
Oh.
Were the documents explained to you in your language?
وروره وایي کوم اسنادونه چې درته تشریح شوي دي د انګلیسي څخه پښتو ته آیا تاسو ته ترجمه شوي دي که نه؟
ترجمه شوي دي خو د اسنادونو مقصد دومره واخله ټوله ته ترجمه دي.
Yes, all documents were translated.
All right. Did you, counsel, did you receive all the discovery and review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it?
وایي کم خبرې اترې چې کم جزئیات چې وکیل درته وړاندې کړل خپل وکیل په خبرو هر څه باندې پوه شوې؟ Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
خپل وکیل سره چې د هر څه په باره کې در سره خبرې وکړل هغه باندې پوه شوې؟ Yes, Judge, I understood.
Counsel, do you waive the reading of the indictment?
I do, Judge.
I need the interpreter to repeat that, please.
Yes,
Counsel,
Judge.
counsel, do you waive the reading of the indictment?
وایي آیا ته دغه جزئیات چې درته وړاندې شو دوی ته دوباره درته تاسو تشریح کوي صحیح ده؟ Okay.
No. Defense attorney, do you waive the reading of the indictment?
I do, Your Honor.
All right, and if you could repeat that to the interpreter, please.
وکیل ته وایي چې د هر څه دی ورسره خبرې اترې دي کړي مرور کړي دي د دوباره هغه وکیل ویل چې و ما کړی.
State, are you proceeding on the indictment as presented?
او هغه بل چې دی هغه بله ښځه چې ده هغوی هم وایي هغې ته یې وویله چې مثلا تا هم د دوی سره برخه اخیستې ده دوی ورته وایي چې هو.
Yes, Your Honor.
او وایي.
Right. Did you review the court admonishments with your attorney, Mr. Gould?
تا هم وایي خپل دغه ټول جزئیات خپل وکیل سره هر څه خبرې اترې دي وکړې ورسره که نه د وکیل سره؟
ما ټولې خبرې ورسره وکړې.
Yes.
Right. You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
وروره وایي ته په دې پوه شو چې مثلا ستا په هغه شی کې چې تا پیدا کړی و هغه د 1 ګرام څخه مثلا کم یو تقریبا 1 ګرام اندازه مواد مخدره ټوکي وي چې هغې دا چې دی فلاني یو جرم دی او همدارنګه د دې باعث کیدی شي دا جرم چې تا د مثلا 100 نه تر 2 کالو پورې تا جیل ته ولیږي او همدارنګه $10,000 پورې جریمه در باندې راشي.
او دغه خو ما پیدا کړی و نور ما لیدلی نه دی چې 1 ګرام و څومره و خو ډبه یې ما راواخیستو پیدا کړو زه ځان نه مجرم ښیم نه ځان نه زه صحیح ښیم.
Yes, that is correct, but I have found that, but I didn't know how many grams were in there, what was inside that box. I just found it.
All right. Do you want a jury trial?
وروره وایي ته غواړې چې هغه وکیل چې درته ویله ما خبرې باندې کومه عریضه کوې که نه؟
وکیل چې سره ته وویله خبرې زه منم.
I talked with the attorney and I agree with him.
So do you want a jury trial or do you want to enter into this plea bargain agreement?
لکه ته غواړې چې د هماغه شیان چې وکیل درته ویل ته په هغې باندې راضي یې که ته غواړې چې بله عریضه وکړې؟
نه زه په هغه باندې راضي یم وکیل چې سره ته وویل.
I follow my attorney's agreement.
All right. Do you understand you have a right to jury trial for your attorney or you to cross-examine any witnesses the state would call in the right to remain silent?
وروره ته په دې باندې پوهېږې چې دا ستا حق دی چې مثلا وکیل یا کوم بل شاهد چې راشي او مثلا معلومات تحقیقات وکړي چې تا رښتیا هغه کار کړی دا ستا حق دی ته غواړې چې هغه په خلاف وجنګېږي یا نه وایي څه چې وکیل درته ویلی چې هغه مخته وړې
زه خو څه چې وکیل راته وایي هغه زه منم نه راته زه خو ولا ښه پوهېږم.
I understand and whatever my attorney say the instruction, I will follow that. And other than that, I don't know.
All right. If the court grants your application for deferred adjudication, if you're revoked, the court can sentence you up to 2 years in the state jail facility. Did you understand?
وای که چیرې محکمه مثلا دغه شي خپل هغه اعلان کړي چې دغه رضایتمندي ونه مني یا ته په دې پوهېږې چې خدای نخواسته تا 2 کاله جیل ته لیږي
زه به څه ووایم دی قانون وي هغه قانون زه عملي کوم.
Yes, so whatever the law says, I follow that.
My question is, did you understand that?
وای مطلب ما پوښتنه ده چې ته په دې پوهېږې فقط هو ورته ووایه.
Oh.
Yes, Judge.
All right. Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
کله هم تاسې څوک ځورولی یاست دغه کړی یاست چې مثلا تاسو ته اختاریه درکړې یا بل کوم ځورونې در سره کړي؟
No.
No, Judge.
Has anyone promised you anything other than the plea?
لکه بل څوک د پلی نه بغیر لکه وایي چې عریضه نه بغیر وایي تاسو ته کله هم پیشنهاد کړي د پیسو که نه؟
No.
No, Judge.
Are you satisfied with the way you've been represented?
هر څه چې ته وړاندې کوې موږ ته دې وړاندې کړي دي په دې باندې ته راضي یې؟
خو په دې باندې زه راضي یم خو دغه یوه خبره چې د ډبای ما موندلی و زه په دا نه شوم پوهې چې 1 ګرام کې دي څومره کې دي خو دا مو موندلی و مقصد دا کې زه نه ځان مجرم ښیم نه ځان صحیح ښیم.
Yes, Judge, I understand. And the other thing I want to mention that the box that I have found and I didn't know, I don't know like it was 1 gram or how much, but I just found it. And then other than that, I want to add that I not feel guilty or not feel not guilty, but I feel no contest.
That's not my question. I need you to listen to the questions that I'm asking of you. Do you understand?
وای دا زما پوښتنه نه ده وای زه غواړم ته په دې پوه شې چې کوم پوښتنه زه درنه کوم هغه جواب ورکړه ته په دې پوهېږې؟
په څه شو باندې؟
Okay, Judge, can you repeat it?
Inshallah, do you understand?
ته پوهېږې وروره؟
Oh.
Yes, Judge.
All right. If you're not a U.S. citizen, by entering into this plea, you can be deported, denied re-entry, and naturalization. Do you understand?
وای ته که چېرته وایې مثلا ته امریکایي پاسپورټ دې نه اخیستی اوسه پورې یو سټیزن شوی نه یې نو په تا به کیدی شي وشړل شي د دې ځای نه او یا هم ستا هغه کومه ورځ باندې چې ته اپلای کوې هغه ورځ باندې وایي تا د دې ځای نه لرې کړي هغه د هغه کینسل کړي درته او همدارنګه ته به د دې ځای نه وشړل شي ته په دې باندې وایي پوهېږې که نه؟
زه په دې باندې پوهېږم زه چې کته پاسپورټ ته اپلای کوم ماته ویل شوي چې انګلیسي دې نه وي زه کوشش کوم چې انګلیسي مې لږه لږه زده کړې وي زه کوشش کوم چې انګلیسي زده کړم دغه یو 2 کالو کې بیا اپلای ورته وکړم.
Yes, Judge, I understand this all, but I'm trying to get my passport as soon as I can because for the passport I have to have learn English to speak more English. So for that I need time to learn English. Then I can go ahead and apply for citizenship.
Okay, I want you to listen to what I'm saying, and I want you to answer the question that I'm asking of you and nothing else at this point in time. Do you understand?
وروره قاضي چې دی تا ته وایي کومه پوښتنه چې درنه کومه همغه جواب راکړه اضافي خبرې پکې مه کوه فقط دومره درته وایم چې څه درته وایم جواب یې راکړه اضافي خبرې ته پوهېږې په دې باندې پوه شوې؟
صحیح شوه پوه شوم.
Got it, Judge.
All right. If you're not a US citizen, by entering into this plea bargain agreement, you will be deported. Do you understand?
کچېرې وای ته یو اس سټیزن یا د امریکا شهروندي دې نه ترلاسه کړې کچېرې ته مثلا همدا بیا عریضه وکې او ته نه یې بیا کېدای شي ته د دې ځای نه وشړل شي ته په دې پوه شوې که نه got it
You will be denied naturalization. Do you understand?
او کچېرې ته مثلا ولاړ شي هلته نیچرلایزیشن هغه ورقه چې ستا نوم شان درکړي د پاسپورټ په ورځ باندې هغه هم به رد شي ته په دې پوه شوې yes judge
You will not be allowed back in the United States. Do you understand?
ته به بیرته واپس امریکې ته ونه راوړل شي ته په دې پوه شوې got it judge
Counsel, have you been able to communicate with your client through the interpreter?
وای تا وکیل سره خبرې وکړلې د ترجمان سره وکیل ته وای تا خپل تا سره خبرې کړې د ترجمان سره که نه
Now, it's for your attorney to answer.
دا وکیل جواب ورکړي ته غلیک شه
Yes, I have, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him? I need you to interpret that.
وکیل نه پوښتنه وکړله وکیل ورته چې هو ما خپل خبرې اترې ورسره کړې دي او بیا وکیل نه پوښتنه وکړله چې آیا تاسو د تاخې دا په دې باندې پوه شوی دی چې دا کیس تا په خلاف دی تا داسې کار کړی دی او اوس هغه وکیل جواب ورکوي
I believe he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
وکیل ویله چې هو کړی دی او بیا ترې نه پوښتنه وکړه چې دا قانوني خبرې ورسره کړې دي په قانون باندې پوه کړې که نه یې پوه کړې اوس وکیل جواب ورکوي
I do, Judge.
Court will find.
Sorry.
I'm sorry, go ahead.
وکیل ویله چې و ما کړی
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
وایي چې محکمه کې مثلا اضافه خبرې باید ونه شي کم کسان چې والنټیر رضاکارانه کار هم باید وکړي دا هم درته ویلي وو اوس وکیل جواب ورکوي
All right. According to your plea bargain agreement, the state is recommending deferred adjudication and there's an $800 fine. Did you understand?
وروره اوس ته جواب ورکړي چې مثلا د ټولو شیانو په مطابق باندې وایي سټیټ چې دی دا تصمیم ونیول چې د $800 روپۍ به ته جریمه ورکوي په دې باندې پوه شوې yes understand judge
To both counsels, is that the plea?
Yes, Your Honor.
دواړو ته وایي آیا دا عریضه صحیح ده دواړه ویل چې هو صحیح ده
By signing this waiver of appeal paragraph twice, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
د دواړو طرف نه په آخر کې دا ورقه امضا شوه چې مثلا د کوم عریضه چې تا کړې وه دا ستا هر څه د هغې سړي سره تا خبرې کړې دي او په دې باندې ته هر څه باندې پوه شوې صحیح ده yes understand judge
Counsel, have there been any such motions?
No, Your Honor.
او قاضي پوښتنه وکړله چې دا کوم احساساتي خو نه دی هغه ورته ویل چې نه دی
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service, the DOEP course, and random UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
وروره د ایالت یا د سټیټ څخه دوی وایي دا تا نه وړاندیز کړی دی چې ته به 100 ورځې ته به مثلا کومکي کار کوې رضاکارانه کار کوې پیسې به نه اخلې او همدارنګه د DOP یو صنف دی چې هغه باید واخلې او دا چې دی ټول د سټیټ لخوا څخه تا ته وړاندیز شوی دی چې محکمه چې دی یا کوټ وایي په دې باندې څه ویل نه لري
نه پوه شوم بس په دې باندې څه ویل نه لرم
yes judge I got it
All right, then how do you plead? Guilty, not guilty, or no contest?
نو اوس په اخر کې تا نه پوښتنه کوي چې ته ځان ګناهګار احساسوې بې ګناه احساس کوې که هم هغه درېیم چې تا ته هغه سړی ویلی و نو کانټیسټ
د ځان نه بې ګناه حسابوم د ځان ګناهګار حسابوم د کیس په مقابل کې.
So not guilty, not you choose the no contest option.
All right, state any evidence.
کوم شواهد
Yes, Your Honor, state offers States Exhibit 1 and all attachments.
محکمه چې د سټیټ چې دی دوی ته نه دا وړاندیز کوي چې درته څه وویل غواړي اوس درته وایي.
No objection, Your Honor.
اوس وکیل زر خبرې کوي.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it?
هغه کوم ورقه چې در باندې وکیل امضا کړله وایي خبرې در سره وکړلې په هغه باندې پوه شوې. Yes, Judge, understood.
You have a right to jury trial, a right for your attorney to cross-examine witnesses, and the right to remain silent. Today, the state is going to be presenting evidence with just police reports and documents. Do you understand?
وایي ته په دې باندې پوه شې چې ته به ځان غلی نیسې که چیرې شواهد ستا په خلاف پیدا شو او په پولیس راپور ورته ورغله تر هغه وخته پورې ته به ځان غلی نیسې ته په دې پوه شوې. Yes, Judge, understood.
All right, the court will accept the court will accept into evidence state's exhibits. The court will find that the defendant has voluntarily stipulated to the testimony. The court has reviewed the same. The court will find that there is sufficient evidence to find you guilty and defer finding of guilt.
وایي محکمه به په آخر کې دا اعلان کوي چې مثلا د شواهدو په نظر کې نیول سه تر څو چې شواهد پیدا شي چې ستا په خلاف باندې محکمه به دا اعلان ورکوي په آخر کې چې مثلا یا به ته په شواهد نه وروسته یا به ته ګناهکار ثابتې یا به بې ګناه هغې نه هغه بیا وروسته خبره ده. Got it, understood, Judge.
Are we proceeding with sentencing?
Yes, Judge.
Anything to say on behalf of your client?
Only that I would urge the court to follow the plea bargain agreement.
You may repeat that.
قاضي پوښتنه وکړه چې ته څه ویل غواړې ستا خپل د دغه ستا په وړاندې باندې ستا په حساب باندې دی ورته ویل چې غواړم زما ستا په باره کې څه ویل غواړي د خپله خبرې کوي.
All right. Do you have any children?
ماشومان لرې وروره؟
نه ماشومان زه نه لرم.
ماشومان sorry I couldn't hear. Can I ask you one more time?
Yes.
وروره ته بچي لرې؟
نه ما بچي نشته.
No, I don't have.
Court will sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, $800 fine. That will be probated.
Aurora?
Sorry, just 1 second. 120 hours of community service restitution and TAP evaluation out of custody. Follow TAP recommendations. You may repeat that.
قاضي وایي چې کنه وایي دلته چې دی وایي مثلا ته چې مثلا یا کار به کوې 15 ورځې یا مثلا ته د جیل څخه وتلو وخت کې غواړې چې ووځې 160 ورځې مثلا ته باید کومکي رضاکارانه کار وکړې خلکو سره چا سره هر بخش کې دې چې کوله او همدارنګه وایي چې $800 دغه جریمه به ورکړې.
Probation, is there anything else? Field visits 1 time per month until further notice.
وایي میاشتې کې یو ځلې باید تاسو وګورو. So per visit is monthly, sorry, Judge?
Field visits 1 time per month until further notice.
وایي چې یو میاشتې د میاشتې یو ځله به دوی تاسو سره ګوري. Okay,
All right. Is there anything you need else you need from the court to be successful?
اورورا وایي داسې څه نور غواړي د محکمې په وړاندې باندې چې څه ویل لري؟ No, thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, and did you sign it?
هغه ورقې چې درته امضا کړلې وای هغه دې وویله مرور دې ورباندې وکړلې چې مثلا کوم حقونه ستا دي هغه ټول د وکیل سره که نه؟ Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
او په دې خاطر چې ته د هغې ورقې شان دې امضا کړي دي په دې باندې هر څه پوهېدلې نو وایي محکمه په دې کې تا سره غرض نه لري نو خپله عریضه دې خپل هغه وکیل سره به خبرې وکړي وایي په دې باندې خو ته پوهېږې که نه؟ Yes, Judge.
All right, thank you. Thank you. All right, Nicholas Salazar.
Judge, present.
Court is calling 2025 CR 012039 State versus Nicholas Salazar. Can I have the parties announced for the record for the state?
Lauren Espinoza for the state.
Defense?
Attorney John St. Hunter from Mr. Salazar.
Oh, off the record for a moment. But Sean, do you need this iPad? All right. Counsel, have you received all discovery? Did you review it with your client?
Your Honor, I believe so.
Court will find that the state is in compliance with discovery. Mr. Salazar, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor.
Mr. Salazar, did you review court admonishments with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
Did you understand by signing that? I'm sorry. Oh, no, that's yours.
Oh, sure.
That's okay. You reviewed the court admonishments?
Yes, Judge.
And did you sign it in all the appropriate places?
Yes, Judge.
You understand you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Salazar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Anyone promised you anything other than the plea?
Nothing.
Are you satisfied with the way you've been represented?
Yes, Judge.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Oh, sorry, is something going on back there?
Yeah. It's just,
Okay.
it's just me talking loud.
Not that we're calling anybody out.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, there's a $1,000 fine to be probated and the state recommends deferred. Did you understand that?
Yes.
Counsel, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, regular random UAs, and the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
I believe it is. Yeah, you're right.
State, any evidence?
Your Honor, state offer states exhibit one and all attachments.
Did you review the waiver? Oh, any objection?
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
I would ask that the court follow the plea agreement as negotiated between the state and my client.
All right. Do you have any children?
No, Your Honor.
Do you live with any minors in the household?
No, Your Honor.
Do you live by yourself?
I just have 2 dogs. It's just
Oh, okay. What type of dogs?
husky and a Catahoula.
Oh, husky in San Antonio. That makes for hot times. All right, the court will sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, 120 hours of community service restitution. Probation, you conduct an hour for every sober support meeting that is completed. There's a $1,000 fine that will be probated. TAP evaluation. Out of custody, follow recommendations. If you're drug tested today, what would the results be? All right. All right, probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor. I'd just like to ask the court for one thing on the record, Your Honor. My client is a cook at a restaurant. His take-home pay is slightly less than $3,000. I would ask that the probation fees be set to the statutory minimum.
Oh, he'll have to provide proof of that, and then the court will make a consideration on that.
Thank you, Judge. I appreciate it.
All right, and where do you cook?
At a downtown restaurant, a steakhouse.
All right, and what is your specialty?
Well, I do the saute and prep,
Okay,
so a little bit of everything.
all right, awesome. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you've waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, make better choices. Good luck to you.
Thank you.
Thank you.
Judge, thank you for the court's time. I appreciate you, Your Honor.
All right, thank you.
Merry Christmas.
Merry Christmas to you too.
May I please be excused?
Yes. Ruben Martinez. Court is calling 2025 CR 011513-02 and 2025 CR 011514, State versus Ruben Martinez. Can I have parties announced for the record?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
And are you Mr. Martinez?
Yes.
And each of the cause numbers, did you review with your attorney the application for deferred adjudication? Did you understand it and sign it? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
Did, and we did review it.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the true bill of indictment with your attorney, Mr. Martinez, and did you understand? Counsel, do you waive the reading of the indictments in each cause number? In each cause number, state, are you proceeding on the indictment as presented? Mr. Martinez, in each cause number, did you review the court admonishments and defendant's waivers with your attorney? Did you understand it and sign it in all the appropriate places? And cause number ending in 02, you're charged with obstruction or retaliation, and cause number ending in 14, you're charged with terroristic threat or impersonation of a public servant. Both of those are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I did understand, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Here we are.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Here we are.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine in each cause number?
I do.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Martinez, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did, Your Honor.
In each cause number, the cases are to run concurrently. The state is requesting that your fine be set at $1,200. The state is silent on your application for deferred adjudication. They're recommending community supervision. Did you understand that to be the plea in each of these case numbers?
Yes.
And in one cause number, they're taking in consideration 2025 CC 013418. Did you understand?
Yes, Your Honor.
Defense is at the plea?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph in each of these cause numbers with your attorney? Did you understand it and sign it in both places?
I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do, Honor.
Counsel, are there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There be 120 hours of community service restitution, mental health evaluation, MRT, and parenting classes. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then in each offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor. State offered State's Exhibit 1 and all attachments in both.
No, Judge.
All right, state, have you had a chance to speak to any complainants?
Yes, Your Honor.
All right, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports, but most importantly, there will be no live testimony? Did you understand?
Yeah.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
Yes, Judge. Your court will notice that this offense took place around Father's Day. It was around Father's Day when the mother of his child, who was living in San Antonio, and my client was in El Paso, the mother of his child was denying him access to his son, was not allowing him to have contact with his son via phone. He, in an extreme moment of frustration, he called the non-emergency SAPD number and made a series of inappropriate, criminal, and hostile remarks on recording on 911. His goal was to get 911 and officers to his the location of his son. Unfortunately, he did not know the location of his son or the address of where he was staying. That is to the degree that the mom kept information from him. As he's making these calls, he became incredibly frustrated, which is no excuse, but it is a description of what he was going through. He made a series of calls and he which were inappropriate, and he totally lost a sense of what was appropriate.
So given that circumstance, he realizes, number one, that he accepts that he just made a decision to have a relationship and have a child with somebody that behaves this way. He realizes that his behavior is incredibly inappropriate. He realizes that it was criminal. And as a result, we have negotiated with the court's approval the probation. I have taken a step further and we're asking the court for deferred status. He does not have a criminal record. He is 45 years old. He does not have. Yeah, he does have some formal education.
So does he live here in San Antonio or is he in El Paso?
At the moment, he lives in San Antonio. Now, if he has expressed to me that if he does take if he begins to struggle again in San Antonio financially, he's going to move back to El Paso with his mom.
But here's the thing, you're not allowed to move anywhere unless you receive permission from the court. Do you understand?
I do want.
All right, so this is what the court will do. And what is the name of the mother of your child?
Sadie Kirsch. SADIEARKIRSCH.
Sorry, A-R,
The
the last name.
KIRSCH.
Oh. This is what the court is going to do. Court is going to sentence you to 8 years deferred adjudication in cause number 2025 CR 011513-02. There's a $1,200 fine that will be probated. This will run concurrent with 2025 CR 011514. Taking consideration 2025 CC 013418. There's to be 120 hours of community service restitution. 100 of those hours we deem satisfied upon completion of anger management. The remaining 20 hours will be deemed satisfied upon completion of parenting. There's to be a MIC evaluation in custody. There's to be no contact with Sadie Kirsch except through the parental portal. Proof of employment within 45 days of a release. No employment as a home health care provider or with minors. Field visits 1 time per month until further notice. Probation, is there anything? Just one, sorry. There's to be regular reporting by Zoom or in person and regular random UAs. Probation, is there anything else?
Okay.
Is there anything else you need from the court in regards to that cause number?
A question, Your Honor. Me and my wife are already using a parental app since we're going through.
Well, that's what I'm saying. You'll have to contact, you're only allowed to contact her through a parental app. If you all are in court for civil hearings, of course, you can proceed with that. All right. And cause number 2025 CR 011514. The court will sentence you to 8 years deferred adjudication. $1,200 fine probated. This is to run concurrently with 2025 CR 011513-02. 120 hours of community service restitution. 100 hours deducted for completion of anger management. The remaining 20 deducted for completion of parenting classes. MIC evaluation in custody. No contact with Sadie Kirsch except through the parental portal. Proof of employment within 45 days. No employment as a home care provider or with minors. Field visits 1 time per month until further notice, and regular reporting by Zoom or in person, and regular random UAs. In each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do, Your Honor.
You have to make better choices, right? I know that custody issues, people get heated with that, but you can't do that. You'll have to use the legal system. You understand? All right, good luck to you. Thank you. Rios, Jerson Rios. Yes, please.
So the last time that we were here, defense had obtained an order from the court to retain a expert.
Yes.
So that was completed. The state did make the motor vehicle available to them. Mr. Brera stated that the expert is just putting the report together. I did give him an offer today, so I believe that he was just waiting for that defense report to be generated. He was gonna give me a copy, but he was requesting a plea deadline.
All right, Ms. Ferguson, I need a plea deadline date. Put it for the end of January, please.
January. January 29th.
All right, Ms. Ferguson, if you'll let Mr. Rios know, your next court date is going to be January 29th for a plea deadline date. All right, thank you. Who's next?
Oh, I'm sorry, Judge. It's gonna be Caitlin Jeffries.
And what page is she on? What page is she on?
She's on the last page, Judge, on page 19, 4 down.
Yes, counsel.
So Judge, you had asked me to confer with probation. The court had signed an order regarding an evaluation for Ms. Jeffrey to potentially be placed in DDRF. But one of the issues last time was that she's currently on parole and we wanted to see what parole would do. And what I was on the court before we broke last was that she had been ordered to go to safe plea as part of parole. And I think what the court was saying was that you were going to order safe plea to run concurrent perhaps once she's on probation. What we don't want though, obviously, is for her to have to do safe plea for parole and DDRF. For
All right,
probation.
this is my suggestion. If you could get in touch with her parole officer so that parole officer can talk to probation and we'll come up with a solution.
Yes, ma'am.
All right. And I will tell you, I've done a lot of parole hearings in my past, so I know it'll be easy to get in touch with your parole officer. All right, and then when you're ready to come back, just let us know and we'll figure something out.
Okay, so no court date set for now and then just reach back out to
Yes.
them later. Okay.
And as soon as that's done, we'll take it up.
Okay, Judge.
All right, thank you.
Thank you.
Thank you.
And thank you. Who else?
David Crenshaw, page 14, 3 down.
David Crenshaw. What is happening with Mr. Crenshaw?
Judge, we've conferred with the state, and I've conferred with my client. They made an offer, so we can have a plea deadline setting.
All right, I need a plea deadline date.
You want in 3 weeks, Judge, or in mid-January, or
No, put it in the third week of January.
I can do the 20th is a Tuesday, the 22nd is Thursday.
January 20th.
It's a Tuesday.
January 20th.
That's fine.
Okay.
All right, thank you. Thank you, counsel.
You're welcome, Judge.
All right, who's next?
Eric Mason, page 5, 4 down.
Eric Mason. Hi.
So Judge, today was the plea deadline. We've decided we want to go to trial.
All right. How long do y'all expect this trial to last?
Maybe 3.
All right, Ms. Ferguson, I need a 3-day jury trial date.
Yes, ma'am. February 2nd.
I think I'm gonna be out that week, Judge, for a seminar.
All right.
February 23rd.
Perfect.
All right, your jury trial date is going to be February 23rd. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you. Vincent Gonzalez. All right, what's happening with this case?
Yes, Your Honor. I received the discovery that was missing.
Oh, I'm
today.
so sorry. Ms. Ferguson, what page is that again?
Page 5, Judge. He's on page 5.
Ah.
on 7 pages.
All right, so you received the discovery?
Yes, Your Honor. And I'm asking additional time for a plea deadline.
All right, Norma,
Yes, ma'am.
set this for a plea on that Thursday in the first week. There'll be no further extensions.
January 8th.
All right, your plea deadline date is going to be January 8th.
I have a vacation on file
For when?
until January the 12th.
All right, Norma, set this for a jury trial date and a plea deadline date after January 12th.
I can do the 13th, Judge.
All right, we'll be back on January 13th. That'll be your jury trial date and your plea deadline date.
Yes, Your Honor, and I have a question. Is it a good time to address motion to set bond? I've conferred with the state.
No. All right. We'll make sure that that's sent to, Judge Nahara to hear. John Ramirez. All right, counsel, are you proceeding on the motion to revoke?
Your Honor, it's our understanding that the state, in conjunction with probation, are asking that he be terminated unsatisfactorily.
All right, so does anyone have any paperwork for me?
So I didn't know if we were gonna just move forward with NCR or if we're gonna withdraw and ask that the court go along with the.
Do y'all want to withdraw?
Sure. I think the consensus, if the court's okay with that.
All right.
we're allowed to withdraw.
And so the mental health issues have been addressed?
Yes, Judge.
Okay.
Regarding that, Judge, speaking to my client in more depth, like he did tell me that he suffered a hit and run in his mid-20s, and that left him with the traumatic brain injury, as well as rods having been placed on the right side of his whole body. So he's been experiencing chronic pain. He's looking to get that addressed medically, and also to see a doctor. He has an appointment to see a doctor next week to address his physical issues, Judge.
Okay.
And that's why he missed a couple of the drug tests. But other than that, Judge, been no usage. His sister is his payee. He gets disability for his issues.
Okay.
And she also attested that there's no issue to the drugs, and he's been on since 2017, Your Honor.
Okay. All right. All right. Thank you. Thank you. Thank you. All right. Who's next? We need to clear out the box.
Nicholas Humus, page 8, down.
Nicholas Kionis. All right. What is happening with your case?
This is Mr. Quinones' first time in court on this case.
Okay.
He was supposed to be here on the 10th of October, but there was some confusion. Both myself and Mr. Jeffrey Scott are representing him, and we kind of just got crossways. Our wires crossed on it. I'm on the bond. What I'm asking the court to do is consider withdrawing the judge's warrant, giving us some time to come back and review the case together, consider the offer. But I've already conferred with the state about the case and about a possible offer.
All right. So because of the changes in the law, we'll have to have a full blown hearing, and I can't do that today.
Okay,
We can have it referred to Judge Nahara for a hearing on that.
that's fine.
Because tomorrow I have mental health court issues to take care of. All right, Ms. Ferguson,
Yes, ma'am.
they want a bond on this case, so refer that to Judge, they're asking for a reinstatement of the bond. You need to refer that to Judge Nahara or Judge Halstead.
Yes, ma'am.
Just my question was the bond was a bond forfeited? 'Cause looked
Oh,
like
it was a
just
judge's warrant.
Right, so would we just, since my understanding procedurally, we would just need the court to withdraw the judge's warrant.
The bond laws have changed. So I can't just withdraw the warrant. There has to be a hearing.
Okay.
All right. All right, so what we can do, Norma, see if you can see if Judge Nahara or Halstead is available for tomorrow. If they're not, I'll take it up tomorrow.
Okay.
All right, thank you.
Mr. Lozano, we had a plea deadline date. I was just saying, I think he might have been next because you just called Mr. Fish. We're not accepting the offer and we just need a trial date.
All right, and that's Lozano.
Yes,
What
ma'am.
page is Lozano on?
Let me look at,
No, we're not accepting the offer.
page 5, 2 down.
All right, Mr. Lozano. How long do y'all expect this trial to last?
4 days, Your Honor.
All right, Ms. Ferguson, 4 days.
March 24th, Judge.
All right, your jury trial date is going to be March 24th. Mr. Lozano, your plea deadline date has expired. The court will not accept any plea bargain agreements without good cause. Otherwise, you have to plead open to the court.
And on Mr. Fish.
That'll be done by Zoom, and everybody needs to be here by Zoom.
At
So
what
they
time?
can zoom in tomorrow too?
Yes, you can Zoom in tomorrow. And Norma, put it at 11:30. You talking about Padilla? Who are you talking about?
On Vargas.
Marcus, it's a plea, Judge.
What page is that? Is Vargas in custody or on bond?
In custody. They're just sitting back right now.
All right, so what we can do, Norma, bring that back then for a plea the first week and, because you're not available tomorrow, right? All right, oh, no. Norma, bring that back for the first week in, January for a plea.
Can do that for that.
All right, so we'll come back on January 5th for a plea.
All right.
Thank you.
Do I need to sign something?
No.
Okay.
And Your Honor, is it okay if we just need a plea deadline date with Mr. Fish?
No, I think
We got-
today is his plea deadline date.
But we didn't have an offer, Judge. And where's Melissa?
Does Michael need to be sworn in right now?
We
already did.
All right, thank you.
Areas, right?
Yeah, she just went in. Oh, perfect. Okay.
No, today is the plea deadline date. It's been extended. There was a plea deadline date on November 18th.
I'll see you tomorrow.
Then it was extended to December 9th, and now we're here. That's what's in the notes.
Yeah, that's, well, Your Honor, he wasn't accepting what they, so we can get a trial date for him too.
All right, Norm, I need a jury trial date on Mr. Fish. Yeah, it shouldn't take that long.
That one, I'd say maybe,
You want to put that the first week in January?
so that wouldn't even take 3 days.
January
Probably take maybe 3 days.
All right, January 5th.
January 5th, thank you.